Greetings viewers and subscribers.
Yeah, watch Popeye's mama. Where I watch?
So let me ask you something. Let me ask you something. Have you hit on the love button as yet? If you have not yet done so, remember to hit on it. Also, if you are over here watching our videos and you have not yet subscribed, hit on the subscribe button as also.
We give you the facts, it's not what you think. Popeye Newsling, Young King, 1 yard, bless.
Good morning, Popeye. Grandma watch Popeyes every morning and every night.
What am I think? What am I think? You're listening to Popeye News Links. This is the Admiral Tibet who I represent, and remember, the time is so serious, cantankerous and dangerous. This is Popeye News Links.
The first verse of the national anthem. It goes like this. Sing with me. Yeah man, stand up. Anywhere you are right now, get up and stand up. Stand at attention. You can stand at ease. Eternal Father, bless our land. Guard us with thy mighty hand. Keep us free from evil powers. Be our light through countless hours. To our leaders, great defender, grant true wisdom from above. Justice, truth be ours forever. Jamaica, land we love. Jamaica, 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 land we love. So, here's some how, when I was singing the chorus. Boom.
Mr. Genius, without a murder, I think it's fair
I'm down on my knees. I learned how to stand because I can't even walk without you holding my hand. Can't even walk without you holding my hands. The mountain is too high and the valley is too wide. Down on my knees, I learned to stand. Father God, I can't even walk. Unatan there laugh, yeah? Unatan there laugh. Morning, I want to do serious times, serious times. Thanks for joining. You know, so court starts 10 o'clock, right? Court is scheduled to start at 10 o'clock. So, as soon as we get the live feed from the gun court, presided over by His Lordship, the Chief Justice, Mr. Bryan Sykes. As soon as we get the notification, we are going to be joining the gun court. So, stand by for that. But this morning will be the sentencing of the wife killer, Jolyan Silvera. In November 2023, on a Friday night, the children of Jolyan, one of the children, Dana Thompson, Papa, call me number. I don't know your number, Dana. I don't know your number. But they found Melissa dead. The police, Jolyan claimed he was on the road when he got the phone call from one of the children. He went in, according to him, and he called in the police. The police went in, and according to the police, when he touched Melissa, Jolyan ball out. Jolyan, who know what he did, in ball out. So the police did not do all of the check, but they're supposed to check. And they're supposed to inspect the body properly. The policeman didn't. But what the police did was that he recommended that a postmortem be carried out. Now, for persons who were saying that the police was there to assist Jolyan in a case of murder, if that was the case, the police would not have recommended that a postmortem be done. So, the police recommended that a postmortem be done. Jolyan, things start bust out now, so boy, postmortem done and gunshot residue found and whatever. The police, them seize Jolyan's gun, interview him in front of him lawyer. The lawyer, Mr. Peter Champagne, him started saying him client is not a suspect because remember now, a lawyer is retained to protect his client's interest. And the lawyer acting on the advice of his client. Listen to this TVJ report.
The attorney for Jolyan Silvera says the former parliamentarian is not being treated as a suspect in the police's investigation into the murder of his wife. Initial reports claim that Melissa Silvera passed away suddenly in her sleep on November 10, but a recent autopsy report revealed that 3 bullet fragments were found inside her body. In a statement today, attorney Peter Champagne KC said his client has been cooperating with the police and is not a suspect. Mr. Champagne encouraged people not to speculate and to be mindful of remarks they make, particularly on social media platforms. He adds that the police investigation must be allowed to continue without prejudice. Our news center understands that 2 properties owned by Mrs. Silvera were searched yesterday by investigators. The former MP's licensed firearm has been seized and sent to the government lab for testing.
So that was then, you know, that was then. Until Melissa Silvera, Jolyan Silvera was charged with murder.
Evening. Former Member of Parliament Jolyan Silvera has been charged with murder.
The charge is in relation to the killing of his wife at home in November last year. He was charged within hours of him being arrested on Thursday. The former MP is scheduled to appear in court next week.
Now, Kirk Wright was at the Major Investigations Division, MID, last night as the dramatic moments unfolded. He has our report.
After a brief question and answer session, Jolyan Silvera was handcuffed and whisked away in a waiting police vehicle parked outside the Major Investigation Division Thursday night. His attorney, Peter Champagne, who spoke briefly to the press, insisted his client is innocent.
Of course, there is concern, and what I will say is that he is maintaining his innocence, and we will see what happens in the process.
But the police say they have enough evidence linking Mr. Silvera to his wife's murder. Deputy Commissioner of Police Fitz Bailey is in charge of crime.
About 12 midday, Jolyan Silvera, age 52 years old, land developer, was formally charged by the police, that is the Major Investigation Division, for the murder of his wife, Melissa Silvera.
He also revealed that the former MP could be in more trouble.
The investigation continues as we believe that there are other charges that will be laid against Mr. Silvera.
Initially, it was reported that Mrs. Silvera died in her sleep at home on November 10. Sources say a photograph of the scene after the police were called showed blood stains, and that ignited the suspicion of the investigators. Things began to look bleak for the former politician a month later after an autopsy discovered bullet fragments in his wife's body. It further revealed that she was shot twice in the abdomen. That discovery triggered a new round of investigations by the Major Investigation Division, which is spearheading the investigation. The incident has resulted in widespread discourse, with Mr. Silvera's lawyer, Peter Champagne, cautioning social media, arguing that public comments could negatively impact the victim's young children. Melissa Silvera was laid to rest last Friday. Her husband, Jolyan, openly cried through the tributes as he clinged on to his youngest son. Of note, none of the tributes mentioned Mr. Silvera, including this one by former PNP President and Prime Minister P.J. Patterson. He said, "This tribute ranks among the most difficult to write. So much has to be left unsaid." Kirk Wright, TVJ News.
Because even PJ could have said and a wicked boy kill him wife. Even the blind could have said. But, you know, since Jolyan has been arrested, he has been in jail. All kind of, like the lawyer try getting bail for him. Parish court and to the High Court and to the Supreme Court, and everybody rejected. No bail, no bail, no bail. So he will be sentenced today. Now, my good friend and one of the person who I admire, Miss Diane Jackson Miller. I started watching this, but I didn't watch everything that Diane has to say about the sentencing for today. She posted this video about 2 hours ago, and I would implore if you go watch Diane's video. And if you haven't yet subscribed to Diane's channel, Diane is a lawyer. Apart from being a radio talk show host, she's a lawyer, very, very good lawyer. So sometimes we have some little things that we want to know. Diane bring it to us, and her channel is called Time for Tea with Diane Jackson Miller. Make sure you go subscribe. But listen to a part of what Diane had to say about the sentencing today. Listen to this.
This is a final in a 3-part series I've done, previewing the sentencing of Jolyan Silvera, who shot and killed his wife. Remember, initially, he was pretending she died from natural causes. Then he was arrested for her murder. After an autopsy revealed bullet fragments in her body, he pleaded guilty to manslaughter and using a firearm to commit a felony. Sentence is pending. Let me just stop and say condolences to the family and friends of Melissa Silvera. I know it must have been an extremely difficult period, still is a very difficult period. The sentencing is going to be difficult as well. There was a protest in Emancipation Park in New Kingston as well as in Montego Bay. They wanted to call attention to gender-based violence, to continue to call for justice for her killing, and to add their voice to the discussion about sentencing and say how much and what kind of sentence they think he should get. So an important thing to remember, first of all, is that Silvera pleaded guilty to 2 charges, to manslaughter as well as using a firearm to commit a felony, which is a manslaughter. And some of my colleagues have reached out and said, boy, Dion, they think the public has been paying attention to the firearm charge. People are mostly focused on the manslaughter charge. I think that's because people think the manslaughter charge sounds more serious. But in reality, when we talk about the sentencing, it's a firearm conviction that's likely to carry the larger sentence, a longer sentence. And you'll see why when I break that down in a little bit. Let me start by reminding you that manslaughter doesn't have a minimum sentence. It does have a maximum sentence of life in prison. Now, the firearm charge, on the other hand, using a firearm to commit a felony, that has what we call a mandatory minimum sentence of 20 years. That means the judge cannot go below 20 years in the sentence and a maximum of 25 years. Now, one of the things that judges do in sentencing is they look at previous cases that have similar facts because of the need to have consistency in sentencing. And in this video, I want to tell you about a case in which a man called Andre Broomfield shot and killed his girlfriend because of an argument over a man. He pleaded guilty to manslaughter. He ended up with a sentence of 18 years. So immediately we know Silvera should be getting around that on the manslaughter conviction. Now the case is called Andre Broomfield. It's relatively recent, 2024, and there are a number of similarities to the Silvera case that you're going to see. Now, what happened is that he was in an intimate relationship with Chantel White, the deceased. Both of them were employed to Master Mac food store in Mandeville on December 31, 2019. Boy, New Year's Eve, look at that. At about 6:15 p.m., she was seated in the lunchroom with a co-worker. Now, he came into the lunchroom and he spoke to the co-worker and said, "Me, I got to tell you something that happened earlier today. Kato come in the lunchroom and hug her up and kiss her on her cheek." And then Chantel responded and said, "I should have put my lip and kiss me." Broomfield then pulled out his licensed firearm, fired several shots at her and ran out of the room. She died as a result of the injuries, and they were noted as cranium cerebral injuries, in other words, head injuries, and multiple gunshot wounds to the face. The following day, January 1, 2020, he surrendered to police. Look at how the man started the new year, man, killing girlfriend, and he goes to jail for years. Anyway, he surrendered to police. He handed over his licensed firearm and an empty magazine. And he spoke to a policeman, Constable Baker, and he said, "Baker, me no know what come over me." He was cautioned. And then after that, he said, "Me take up this girl and give her everything. Build her a 2-bedroom house, pay off her credit card." And me realize that she have another man, the auditor named Kato. Me see the youth a kiss her up. Me talk to her and she had diss me up. Me just snap. The shooting was captured on surveillance camera and it was widely circulated. It was all over social media. It was on traditional media as well. So he was charged with illegal possession of firearm and murder. And he pleaded not guilty to illegal possession of firearm. He pleaded guilty to manslaughter. His guilty plea was accepted as having been done on what they call the first relevant date for the purposes of the 2015 amendment to the Criminal Justice Administration Act. That's the act that allows the judge in sentencing to give a discount if the person has pleaded guilty. So after the judge got a social inquiry report, an antecedent report, that's a report that says any previous convictions. After his lawyer had made a plea in mitigation, that's when the lawyer basically begged the court and said, boy, judge, look at all these good things about my client, don't ease up on the sentencing. After all of that, also a victim impact statement from the deceased mother, from Chantel's mother. The sentencing judge came down with a sentence of 18 years and 5 months. The Crown didn't offer evidence in relation to the offense of illegal possession of firearm. So in comparing this case now to the Silvera case, we're only comparing on the manslaughter conviction because there wasn't any firearm conviction in the Broomfield case. So you see the similarities, right? Intimate partner violence, man say he was provoked and shot and killed her. The big difference here in the Broomfield case is that he never tried hide, right? He never tried cover up the evidence, and the very next day he handed himself into the police. I mean, and knowing his situation, there was a witness, it was in a workplace, so you could argue that he didn't have the chance to hide it. There wasn't any opportunity.
Now, I'm not going to be unfair to Diane. I'm not going to be unfair to Diane and play all of her video here. What I would implore you to do is, there it is, Time for Tea with Diane Jackson Miller. Click on it and go over there and watch Diane's entire video. Diane always come out with some very, very, very good video. Very good videos. So I would implore you to go over there and watch it. So we are waiting for, I don't know if sometimes court not start on time, you know. Sometimes court not start on time. They're saying that they're supposed to start at 10. So we are watching to see if they are gonna be starting at 10. Yeah, man, Time for Tea with from your type in Diane Jackson Miller, it's gonna take you to her channel. Remember me tell you, Diane, I watch Diane, every video I Diane drop, I never get to watch this one because I was doing something else. But Diane, one of my favorite people, she drops some really, really good video. Very, very knowledgeable of the law. Diane Jackson Miller is a bottom feeding hypocrite. What is that? What do you mean by ingenders? What do you mean by Diane Jackson? I think that's about me too. Ingenders? If you say that about Diane, that's the same thing about me too. She's our bottom. What is that? Bottom feeding hypocrite? Same thing that's about me too. So that's how you go. Diane is a hypocrite. Diane is a very, very good journalist here. And we have some little way of calling people names because them say some things what we don't like. I see them thing you call me too. And maybe I called me so already. John Daz or whatever your name is. First me see your comment. Maybe I see anything I call Papa too. So Papa a bottom feeding hypocrite. Maybe I see anything about doing me too. Diane is a bottom feeding hypocrite. You can imagine? A bottom feeding. Maybe I see anything you do with me too. you think so we happy for someone to come over and come view my channel? Because someone who are more hypocrite than people who are not about a hypocrite. You think so we happy when we see you come? Someone who are more hypocrite than people who are not about. Diane Jackson is one of the most educated person on radio. And this guy feels saying can come use my space and this, sir. Listen to me, man. You see someone if you go away, you know. In Jandas, someone if you go away. When I invite you to come over here and come watch your channel, someone if you go away and go drop asleep. No, you're not charged for concealing. No, it wasn't charged. No, it wasn't charged for concealing a crime. There's no such charge, you know, concealing a crime. Maybe you can conceal like a dead body. Diane educated for true, but too biased. Well, it's no people are going to say me biased, sure net. So I say go. No people are going to say me biased. It depends on what angle you look on things from, you know. No people are going to say Papa you biased too. Hey, some people are going to say me biased, so it depends on the angle where you look on things from. So saying somebody is biased, sometimes we bias more than who we are called biased, you know, because somebody don't say what we want them to say. We say them biased. That's how you go, you know. Sometimes we more biased than who we are called biased, you know. No, you know matter sure net. You might not say me biased, but there are other people who are going to say me biased. You sure net? You might not say me biased, but every day, say up the day before yesterday morning, yesterday morning I play one video with one woman that cuss me out, or me biased, because me political. So you might not say it, but others are going to say it. And when people now say what we want them to say, in Jandas, Jandas, you say, me a good man, but other people are going to say me bad. I'm a bias. That's how you go. Yeah, say me good. Enough people are going to say, Papa, in bias, and the boy, Papa, if it this. The feed not start as yet, yeah, people? The live feed from the court don't start as yet. So when I have you waste your time. It is scheduled to start at 10 o'clock. And I keep checking to see what is happening. It not start as yet. But Jolyan, we're waiting on the court and the court to start, you know? We're waiting. But Jolyan, let me read an article from the pastor who baptized her. Melissa Silvera shared a lifetime bond with Reverend Canon Major Kingston, rector of the St. Andrew Parish Court. Let me refresh the judiciary's page to ensure that they don't start over there. He baptized her as a baby, stood by her altar on her wedding day, and welcomed her for countless monthly chats. Yet, being a man of deep faith, could have not prepared him for the day he would lay to rest the woman he had cherished since infancy in such tragic conditions. Boy, that was rough. It was tough. It was very difficult and challenging. It was a very difficult and challenging funeral. Having been there for her baptism, officiated at her wedding, and then at her funeral, under those circumstances, it was very hard. It was emotionally traumatizing. Does I check again? They don't start yet. I'm checking here. I baptized her as an infant. She worshipped here at the St. Andrew Parish Church by herself. And then, when the children got of age, they came with her. Melissa Walter, she got married. She was the manager for the Moda Petroleum Company Limited. She got married to Jolyan Silvera, then Member of Parliament for St. Mary Western, on December 12, 2015. Still checking, let me check again, okay. The wedding was attended by a host of dignitaries, including former Prime Minister P.J. Patterson and parliamentarians Lisa Hanna, Ian Hales, and Michael Phillips. Kingston, who officiated the wedding, said, one second there. Kingston, who officiated the wedding, said photographs from the day captured the mood. The photos would tell you, just like weddings, you know, it was a joyous occasion. Very joyous occasion. She would come and talk to me about life, about things, about life. Never sharing her marital relationship, though. That was very strange for me, the clergyman said. The couple shared 4 children, 9-year-old twins, Adam and Aiden, and 4-year-old Axel. Their other son, Justin, tragically drowned in a pool at their home in 2017 at the age of 2. And if you remember, Jolyan had said that Melissa was cussing him that he was the one responsible for the death of Justin. When the third child passed, that was great pain. Kingston said, but she didn't talk about her marriage, and that naturally spoke volumes. I would say sometimes. So, how things with husbands, with your husband and home? And she would say, it is all right. Melissa, 42, was killed by Jolyan Silvera on November 10, 2023, just weeks shy of the couple's 8th wedding anniversary. Jolyan admitted to pumping 3 bullets into Melissa's body. He has denied murdering her, confessed instead to manslaughter, saying that he was provoked the night of the incident. The pastor said, I was totally devastated by it. I don't recall where I was, I think somebody must have called me and told me, knowing my connection with her. And I was totally devastated beyond distress. The clergyman said the bond he shared with Melissa through the years brings him some comfort. Let me just check on the Judas, the gun court, nothing as yet. The fact that she came and saw me at my office, time and time again, didn't make me feel like I turned her over to anybody. We maintained that connection. And when she came to me, and when she came to see me, we would talk for almost an hour at least. She was a very articulate person, extremely bright, very articulate, and a real thinker, conceptualizer of ideas, a visionary person. But those visits stopped. The conversations ended. One painful final duty remained. I did the funeral for Melissa. The Reverend said softly, still the love people had for Melissa was unmistakable that day. Let me just check back on the judiciary's website to ensure we're not missing anything. Okay. Nothing as yet. I just got a breaking news. A businessman from Savannah Lamar. Took his own life. He used his license gun and took his own life. I just got that business news. I just got that breaking news. The incident took place in Westmoreland, but the businessman owned a business place in Savannah Lamar. I also got another breaking news. That the female who was burnt up, Dacia Forrester, I was just told that she has died. The female in the gas station, no, Jason is true, I confirm it, I got videos of the businessman who killed himself. I got videos of the businessman who died, and it is suspected that he killed himself. Let me put it as far as that, because I'm told that his weapon was found and everything. And it is suspected that hold on, let me just reply to a text. Let me just respond to somebody. I'm doing a live stream at the moment. Yeah, so I was told that see, I get the video, you know. See I get the video. Here's the video. Here's the video I can't show you, but here's the video of the man. And the video I'm looking at, him have him gun in him hand, and him sit down in him vehicle, and there's a bullet to him head. That's the video I'm looking at. So that businessman reportedly took his own life. Listen out for the news coming up. Listen out for the news. But I'm looking for, let me check on the nothing as yet on the judiciary's feed. Yeah, so I was saying that the female, I tried to confirm it a while ago. My sources are saying they are hearing the same thing. The female, Dacia, I am learning that she passed away. And so the female, her sister, Dacia's sister, you know, what's her name? She was also charged for wounding Colette. The case should be going to court, but I can tell you that it's a Chinese man. It's a Chinese man who killed himself, not a Negro man. One of those Chinese businessmen on Great George Street in Savannah, Lamar. And the incident took place in Westmoreland. And the video I got is with him sitting in his vehicle with a gun in his hand and blood oozing from his head. Sometimes, you know, yeah, man, the pump attendant will definitely. Let me just check on the judiciary's website to ensure so we not miss anything. Nothing as yet. I guess the Chief Justice is just taking his own little time. Don't know if he's doing anything in chamber, or they're going to do anything. They're going to do anything in camera before opening it up to the public, because we know how the sentencing thing going on. I don't know if he had asked persons to write right, what them call now, you go and you talk about the character of the Jason, born Chinaman, one of the born Chinaman them. One of the born Chinaman them. But person come and give character evidence. So I don't know how the Chief Justice is gonna do it. If them are gonna come in a court. Court start 10 o'clock, man. When me study a court hard, you know. 10 o'clock on the dot, the judge in a court. 10 o'clock on the dot. But there's no need for summation in this, you know. Jason, yeah. No, really, it's not about the victim impact, you know. Echo or Marvally. It's about the character persons given, because the victim would be Melissa. It's about the character evidence. Persons coming and giving character evidence about Jolyan. So it is likely that based on the facts that the judge plan on going live with it, maybe him ask them to submit them character statement in writing. That is possible also. But we are still waiting. What you say? Pumpy if he play guilty. Pumpy now go play guilty. Pumpy liar now go tell her to play guilty, you know. Pumpy lawyer is saying self-defense. And based on what I said, not because Dacia is no longer here with us, what I said before still stand. What I said before, I still stand by it. And the court, it look like the court agree with me. Because that's what I was saying last week, you know. The fact that she went to court, and on the first day of the hearing, the court grant her bail, knowing fully well that Dacia might pass away. It means, say, whatever submission the lawyer gave to the court when seeking bail, it means, say, the police, the investigator would have said, we are not opposing to bail. The clerk of court would have said, we are not opposing to bail, knowing fully well that Dacia might die. Under normal circumstances, judge no give defendant bail under normal circumstances. Defendant in a cases like these, where it's possible say the victim might die, judge no normally give them bail. So the fact say the judge on the first hearing give her a bail, it means say they are mindful or they are minded to believe that she acted in a self-defense. It's sad, it's sad, it's sad, but this should be a learning experience. It should be a learning experience. It's the same thing with the little school guy that died, you know. It's the same thing with the little school guy that died. I mean, I digress. But it's the same thing in that no, Dana, them have to go charge her for murder, you know. Dana. Them have to go charge her for murder. Them have to go charge her for murder. Not manslaughter. She was charged for assault occasioning grievous bodily harm. Them have to go charge her for murder. Now, the outcome of the case is another matter. I don't think our lawyer will tell her to plead guilty for nothing at all. Neither manslaughter nor murder. The lawyer go ask for the matter to be tried. You know? The lawyer go ask for the matter to be tried. And juror or a jury, I go hear if it reach this so, but boy, it's sad all around. Because Pumpy have to go, Pumpy will have to Mary Mills, provocation. Mary Mills, them not plea, them not say nothing about provocation. Colette's lawyer is saying she acted in self-defense. Yeah, man, them have to go charge her for murder. They can't charge her for manslaughter, Michelle. They cannot charge her for manslaughter. They have to charge her for murder. Christian Papai, the Bible said, thou shalt not kill, and this girl was defending herself. Is she going to hell for that? Clifford, that's not my question. Make a question. Make you answer who go to hell and who not go to hell. That's not my question that we answer. I can't pass no judgment as to who go to hell and who not go to hell. I don't mean that. I don't mean that. But this should be a learning experience. I'm saying walk away from trouble. Betty Ann, this should be a learning experience. Because this year, I know man, them a quarrel over, you know. I know man, them a quarrel over, like what some people are saying. I say it from the first time. But anyhow, I'm still checking, I'm still checking to see if Chief Justice Sykes taking seat yet. But I'm not seeing anything. I'm waiting to see. I'm waiting to see. Let me see what carrying. Let me see what TVJ carrying. Okay. TVJ, them talk about what is to come. Then I join the live stream at night because there's no live stream. But let me hear a little bit from this Oh, TBJ. Let me wait a little bit. Let me wait a little bit on that. Nothing yet from the judiciary. Nothing as yet. There was this case in where the little boy was killed in school and in Ocho Rios on Wednesday. And I carried a video last night. You're asking if, hold on, you're asking if it's a lady who was set ablaze die. Anthony Ray, that's the news I just got. Somebody, one of my PNL detectives just sent me a message. I'm trying to confirm it, but based on that person and the connection with the family, I am tending to believe it, but not yet confirmed. The live stream not ready yet. Not yet confirmed, but I'm still waiting to talk to somebody, and they're doing some checks. No, Jennifer, they're not start yet. The court not start yet. Question, Popeye, what caused the fire after the gas was thrown? The evidence is indicating that a lighter was lit. All right, a lighter, according to the allegation, the female lighter and dash it on her. That is the allegation. Right? That is the allegation. That is the allegation. We're still waiting to see when things are start. We still are refresh the page, not start yet. So it's not like it a go on and the one Papa over here chat too much. You know, I miss nothing as far as that is concerned. But we're just waiting to see. We are waiting to see what is gonna happen. So closing arguments already gone. Is it just sentencing? Everton, that's what I'm saying. There wouldn't be any closing argument again, you know, Everton. There wouldn't be any closing argument. They would be like, because he already pleaded guilty, so there's no argument to close. So there's nothing for the Crown to put forward already. You understand? It would be no mitigation plea, in the sense that the lawyer, his lawyer, will be seeking a lesser sentence. Most likely, you're gonna have witnesses or persons who know Jolyan, persons who know Jolyan come in and beg the judge for, even if I go to prison, not to send him there for too long. So all of that, and that's what I go on now before the sentencing. And that's what I go on. So, we say, yes, Melissa. The questions are meant to ask it. And for me, I grew up and come up, you know, I was always told, no question is a foolish one, you know. So I'll answer question, man. I don't have a problem with it. You're saying that if a lighter was lit, wouldn't the gas station go up in flames? Well, Stephanie, it didn't, you know. The gas station didn't go up in flames, and the allegation is that a lighter was lit. Right? Victim's impact statement. I've never seen that in a Jamaican court, Stella. Stella, I've been to a lot of court hearings in Jamaica, and I have never seen that in a Jamaican court. Victim impact statement. Never ever. I might be wrong, but I've never seen that in a Jamaican court. All what would happen is the clerk will go to the outline the allegation to the judge, and then it's over to the lawyers because the guilty plea is there already. Don't matter what sentence Silvera gets, it will never compensate for the killing of his wife, because the life that they are living in prison, that's not punishment. You think I joke? You think a joke? Hold on, important call. Let me just take this call. 1 second. Another sad news, but boy. So where were we? Don't matter the sentence. That is true. That is true. Because I tell you some things are going to prison, you know. Prisoner them live some serious life in there, you know. Remember me tell you, man. That's what I heard too. And let me just check back and ensure say it no start and we're not missing nothing. It no start as yet. It no start as yet, my people. So we just have to go and wait. Right here, we're still waiting. Clifford, you are correct. But it's still some justification if he's living big, locked up for a long period. Papa, I was thinking Jamaica a few weeks ago. And I find people to be, thinking, you were in Jamaica, Marvally, and you find people to be very angry. Yeah, man, Jamaicans are so angry people, you know. I tell you, some people go out, it's like them out and them say, oh, anybody mess with me today, I kick them. Look here, look at the little schoolboy that was killed. Look at the little schoolboy that was killed. A fight over girl. I carried the news last night. And that little schoolboy used to go to school. He's from Green Island in Hanover. Well, he used to live in Green Island, Hanover. And like I reported, he moved to Ocho Rios last year. And he started attending Ocho Rios High September last year. And I had said I'm not sure why he had stopped attending school in Hanover, but I am told that he just needed a change of location. So I got a video where on Tuesday, he and his brother, according to the stepmother, she sent him to the one who was killed. The stepmother is saying that she sent him to the ATM. And she's saying that the boy, the one that was charged now, Jay, the one who is in custody, she's saying that Jay saw him. And there was an argument. Now, what I see on the video is the two brothers fighting Jay, beat him up, kick him up. But let me just show you, until I start, let me just show you the TVJ report on the killing and what the stepmother and whosoever else is saying. If the live stream start, I'm just gonna switch over to it. But watch this TVJ report and the killing over at center.
Continuing the news. Grief gripped relatives and the Ocho Rios High School family today after the tragic death of a 16-year-old student. The student died yesterday at the hands of another teenager from the school. Now, our reporter Kirk Wright was at the St. Anne-based school on Thursday and filed this report.
Anguish for the parents of Devaney Shearer. Both are struggling to accept that their child is dead. His stepmother laid out his uniform he wore to school yesterday, now stained with blood. Yesterday in class, during break time, another 10th grade student allegedly struck him in the head with a metal chair, leaving him unconscious. His stepmother went to see him in hospital.
When you went and saw him yesterday, what was his condition?
Not good.
No good at all. Me I tell you, no good, no good.
Hours later, Devani was pronounced dead. Reports are that the two boys had a confrontation on Tuesday in the town of Ocho Rios, and it seemed that spilled over into yesterday's attack.
I would send him to the ATM machine, and he went to the one by Champion. And the guy saw him there, grab him and start to fight him. Devani defend himself. Because he might fight him over one girl that Devani no want. Because Devani no depend that.
Devani was a student at another high school in Hanover, but felt he needed a change.
When he attended class, he wasn't getting the work done. Because he said when he go to school...
You hear the stepmother? You hear the stepmother? You hear the stepmother? The guy see him and fight him over one girl why he no want. Kind of depend that. And nobody no left and say, all right, I could go to school Wednesday morning. Go try quash out this. Eh? You hear? I fight over one girl what Devani no want. Because Devani no depend. Look, listen again. Listen. Listen again.
I start to fight him.
Over into yesterday's attack.
I would send him to the ATM machine, and he went to the one by Champion. And the guy saw him there, grab him and start to fight him. Devani defend himself. Because he might fight him over one girl that Devani no want.
You hear that? You see the type of... eh? You see the type of mannerism. But guess what? No, I'm not Devani alone. Because the brother, I know Devani alone. The brother was there, me get the video with them hold down the guy and the one named Devani give him some serious kicks. But, like I reported, because people are saying, I see other news media say that there was a school fight at school on Thursday and Wednesday. I did not care anything about no school fight because I am told persons are saying the guy go back to school and have trouble. Jay. But my information is that the allegation is that the one named Devani was standing in a class and Jay walked up behind him with a chair and hit him in the head. If that is the case, there is no self-defense right there, so. If I saw it happen. Anyone saw it happen, there is no self-defense there, so. And that is the allegation so far. That he was standing in a class and the youngster walked up behind him. But if the parents were aware of the fight the day before, or the step-parents, why they never go to school and go try talk to teacher and try say he might defend himself. Suppose he end up dead then now. He attack him and he defend himself. Kind of fight about one girl what Jane no up because Jane no depend because Devani no depend that blah blah blah. Eh? And now what? When you go deal with it no man go to school, them things we have to learn from them something here, you know. We have to learn from these things. Go to school and go talk to teacher. Echo, you say you hear, say Jay, me complain to the math teacher about Devani bullying him. I hear the same thing too. That's what I hear too. And see them now. One is dead. One is in jail. Two young schoolboys. When the situation could have handled differently. Because you stepmother come out, Jay defend himself. Kind of defend himself. I know so parents talk. Yes, we are going to tell the children say they attack, defend themselves, but we are aware of the attack. We don't just make it slide, so. Go in and go deal with it now and make teacher, me sure the teacher did intervene. I do as the parents go in and go talk. Maybe, just maybe, you know. Because sometimes some people have some things in their head ready to do. We can't start. But just play your part now. Yeah, man, play your part. Most sensible school admin would have called both parents in the brief. Me still a check on the judiciary's page and nothing no start yet. So it's not like every day I may chat too much. I mean, make based on where we are now, we cannot, I won't stop the feed. You know, so Miss now 10:36, Mr. Mr. Chief Justice are taking one time, whatever they are doing. I am sure they are there doing something, you know, what them don't want the public to see. So, when them reach at the sentencing part, now when them pass him sentence, maybe at that time, them start the live feed. But some other things might have go on in a court now. Because knowing the Chief Justice, court are going right here now. Knowing Mr. Sykes, court are going right now. But them are do some in-camera thing, you know? Them are do some in-camera thing. I know lunchtime yet, man. I can't lunchtime yet. Lunchtime, I like 1 o'clock in the Marvally, in high court. Lunchtime, I like 1 o'clock. But I go watch some more of what was about the report from TVJ.
And you know, depend that.
Devonay was a student at another high school in Hanover, but felt he needed a change.
When he attended class, he wasn't getting the work done because he said when he go to school, teacher is not there. Teacher hasn't come to class or anything like that. So he was saying, Mommy, I want to go to Ocho High because I'll get the best teaching there. And he came, and it was good for him.
Devonay's father says he was encouraged by his son's progress at Ocho Rios High, and that he was focused on helping his mother.
Well, everything I world. You just plan to want to make life help him mother and his sister, take him out of the gutter and bring him to life, and him to live like country part of life. You plan to say, when he get big and get left school, the first work he get, not try to help him mother and his sister, bring them out to life.
Now, it's at this premises here on Tay Street in Buckfield where Devonay spent many years living with his father and his stepmother. And while his death has dealt a serious blow to his school community, it's left a gaping hole here in the Buckfield community. Now, many of whom we spoke with about Devonay described him as resourceful and a kind boy who loved to help.
Devonay, he was such a good child. One who would say, would never pass without good morning. If you see him 100 times, you get 100 good morning. Very manners of a child. Who would from school to home.
The news of Devonay's death caused panic and worry among parents who turned up at the school this morning.
It made my heart start beat so fast because knowing me have my child coming to the school is like, that's why I have to be here this morning, because even though I don't know the person who died, but my concern is very into what going on, you know, because as I said, my daughter is here. And I don't want for their work or the woman here say, nothing do my daughter, nobody do my daughter. I try for one her every day, tell her if stay out a problem, no company, no friend, just focus on your schoolwork. Yeah.
The Minister of Education, Senator Dana Morris Dixon, and Member of Parliament for North Eastern and Matthew Samuda visited the school and promised help.
Anything you need in the coming months, because I know that you're not going to just see the manifestations of the trauma and the pain right away. It can be months down the road. So whatever you need in the coming weeks, in the coming months, we're here to provide that for you.
Kirk Wright, TVJ News.
So that is that. So we are still waiting on let me just refresh the page, the judiciary's page. All right, so one of my learned friends sent me something because the person is listening, and I had said something about impact statement a while ago. I was saying we love take correction, you know, we love to teach as well. The person said listening to the live. Normally, they normally have antecedent report, social inquiry report, and victim impact report statement before the sentencing. So I said something about victim impact a while ago. The person is correcting me and say yes. They normally have social inquiry report, and antecedent report and victim impact report before. So it would be a report based on the victim. It would be a victim impact report. Okay. And then, so maybe that is what the Chief Justice going through right now. It is just maybe, you know, maybe that the Chief Justice are going through right now. There's an article in the, I'm still checking out. So I feel like me, Papa, keeping away from the issue at hand. That article in the Jamaica Observer, from vows to, hold on, let me just refresh the page and ensure, okay, not start yet. From vows to verdict, former MP Jolyan Silvera faces up to life in prison. And you, the person who sent me the report, you know, sent me the text a while ago. Me just see the first one, you know. Just seeing the one you sent me from Saturday. All right, no problem. I'll deal with it. Yeah? I'll deal with it. It began with a fairy tale wedding on December 12, 2015. At the story, let me just check back the page. Okay, nothing as yet. At the storied St. Andrew Parish Church, as the public was invited into the lives of then PNP MP for St. Mary Western, Jolyan Silvera, and his longtime sweetheart, prominent socialite and business executive, Melissa. It ends today in the gun court of the Supreme Court in downtown Kingston, where Jolyan Silvera will be sentenced for the November 10, 2023 killing of his wife, less than 8 years after that wedding, which was attended by many of Jamaica's movers and shakers. Let me just check by the page again. Nothing as yet, same way. Jolyan Silvera, who shed copious tears at the January 12, 2024 funeral for his wife in the same church where they wed, was arrested and charged with her murder 6 days later. After professing his innocence for 2 years, Jolyan shocked the nation on February 2 when he entered a guilty plea for the lesser offenses or for the lesser charges of manslaughter and using a firearm to commit manslaughter or to commit a felony. Today, it will be up to Chief Justice Bryan Sykes, the head of Jamaica's judiciary, to announce the fate of the former parliamentarian following submissions from prosecutors and defense attorneys and expected character references. That me did talk about. So maybe I that go and know character evidence and all these things. Under Section 9 of the Offenses Against the Persons Act, Jolyan Silvera could be sentenced to life in prison for manslaughter, with the judge setting when he would be eligible for parole. But a senior attorney who has been practicing for more than 30 years told the Observer that he has never, ever seen a judge handed down a life sentence for manslaughter. If you look at the sentencing guidelines, you will see it says about 3 to 15 years for manslaughter. However, it makes provisions that if the particular circumstance are such that the judge should go outside the sentencing guidelines, then the judge can go outside, but has to state the reason why he's going outside. Let me check out the page again to ensure that not start yet still. So as we continue, and if you look at a couple of the current cases, the current case laws on the point, in terms of sentencing, there is a case there is the case of Cornelius Robinson. Oh, I remember Cornelius, him the killer, the young girl in Westmoreland, where the judge explains clearly the starting point in terms of the number of years can be very high depending on how heinous the offense is. A noted attorney who wished not to be named said, in that case, 37-year-old Cornelius Robinson pleaded guilty to the murder of a 14-year-old girl who he had reportedly had a relationship with in Westmoreland. He was sentenced to life imprisonment with a stipulation that he served 25 years before being eligible for parole. Let me check the page again, nothing as yet. But lawyers representing, you know, I'm going to kill a case the one day. But lawyers representing Robinson appealed the time he should serve before being eligible for parole, as they argue that the judge did not take into account the time he spent in prison before he was sentenced, the fact that he pleaded guilty, and other factors. However, the Court of Appeal concluded that although the trial judge erred in his approach to sentencing, the sentence imposed was not manifestly excessive, as it fell within the range of sentences imposed for the offense of murder, for which there has been an admission of guilt. On Thursday, the senior lawyer told the Observer that he would urge the judge to go outside the sentencing guideline in the Silvera matter. He said, I would, in my submission, also invite the judge not to give the discount because of how heinous the offense was, which is that after he shot the woman, he no call no doctor, he no call no police, him leave the scene and leave the children to discover the body. So this lawyer is saying he's urging the judge to go outside sometime after 6 o'clock the next day. One of the children went into his parents' room. Let me just check on the page. Let me refresh it and see what is happening. Nothing as yet still. Sometime after 6 o'clock the next day, one of the children went into his parents' bedroom and discovered his mother's lifeless body on the floor next to their bed. He noticed that there was blood coming from her orifices and that her dress was covered with blood. He ran to the bathroom and alerted his brother, who accompanied him back to his parents' bedroom, where they both checked for signs of life from her body. They tried to make contact with their father and they were eventually successful. Now, when I talk about the children, you know, this young man killed Melissa, you know, and left the children to find her dead, you know. He indicated in a witness statement that he called the Stonehill police station while on his way home after he had spoken to his son. Upon his arrival, let me just check by the page. Nothing yet still. Upon his arrival, Silvera went into his bedroom based on the statements from his children and saw his wife in a sitting position with her head leaning forward at the side of the bed. He claimed he touched her, spoke to her, and found out that she was not responding. Sometime after, a first responder, who was a police officer of the Stonehill police station, arrived at the house and went into the bedroom where he saw the body of Melissa Silvera. He took a photograph of the body and had Silvera covered the nude section of the body. The police officer did not further examine Melissa because Jolyan was there pretending to cry or pretending to cry. The police officer, after learning from Jolyan that his wife had no known medical condition, indicated that a postmortem examination would be conducted to determine the cause of death. A postmortem was scheduled to take place on December 1, 2023, but on that date, the pathologist discovered that there were scars on the body. The postmortem examination was done on December 15. 1 second, let me check on something. Oh, okay. The postmortem examination was done on December 15. That would have been what? 3 days after them 8th wedding anniversary, you know. Hold on, let me just check on the page again. Nothing no start yet. You're not missing anything. The postmortem examination was done on December 15. And the pathologist noted that there were 3 gunshot wounds. 1 perforating gunshot wound to the front of the right thigh. 1 penetrating gunshot wound to the left side of the lower abdomen. And the 3rd, a superficial penetrating gunshot wound to the right side of her lower abdomen. The detectives and the first responder returned to their home on December 16. So 1 day after them get the postmortem report, or was told that she was actually killed by gunshots. The next day, the first responder returned to their home and entered the bedroom, where they noticed that the floor had been retiled, the furniture sprayed over, the mattress was replaced with a new one, and the walls freshly painted. The children's room had also been tiled over. The father, the wife killer, Jolyan Silvera, he indicated that no one had told him that he could not make the changes to the rooms. His arrest and charge on January 18, 2024, followed ballistic tests, which indicated that the projectiles recovered from Melissa Silvera's body was from her husband's licensed Glock 9mm pistol. He has been behind bars ever since. So, we are still, I'm just checking on the page again. Nothing as yet, still waiting. And it is likely, like I said, that them are do that they are doing some things but they don't want the public to see as yet. But you know, I'm gonna go back, you see? I'm gonna go back to Melissa's funeral service. And I'm gonna show you Jolyan's mother reading a tribute that was written by Jolyan on behalf of his wife, Melissa. I'm going to show you Jolyan's mother reading the tribute.
Good morning, everyone. This is Jolyan's remembrance, but I am reading it for him. Love is patient. Love is kind. It does not envy. It does not boast, and it is not proud. It does not dishonor others. It is not self-seeking, It is not easily angered. It keeps no record of wrongs. Love does not delight in evil, but rejoices with the truth. It always protects and it always trusts. It always hopes and always perseveres. Love never fails. But where there are prophecies, they will cease. Where there are tongues, they will be stilled. Where there is knowledge, it will pass away. And that's from Corinthians 14, verses 4 to 8. Melissa Patrice Walter Silvera was born on September the 11th, 1981, was not merely a collection of moments within our home. She was the heartbeat. Her story, woven into the fabric of our family, unfolded with grace, determination, and a brilliance that illuminated every corner of our lives. From the early days of Mona Prep to a time at Immaculate Conception High, Melissa exhibited a rare combination of composure, articulation, and exceptional intelligence. Her journey continued to the University of Virginia, where she delved into the world of chemical engineering, a field that resonated with her inquisitive mind and determined spirit. Upon her return to Jamaica, Melissa transitioned into the professional realm, finding her place at Petrojam as a chemical engineer. Her talents, however, extended beyond the technical realm. She possessed a natural flair for planning and logistics that would become the hallmark of her career. Even after leaving Petrojam, Melissa continued to navigate the business world with her mother, Leslie, showcasing valor, resilience, and an unparalleled work ethic. Melissa's aspirations were not confined to the workplace. She was a force of nature, a nation builder in her own right, whose ambitions were deeply rooted in a desire to create a brighter future for our family and country. She always had this dream to build her own logistics hub in Cow Bay, St. Thomas, and she invested both her time and resources in building out a shovel-ready project. Her relentless pursuit of progress, sometimes misconstrued as overbearing, was in reality a manifestation of her profound love, especially for her country and her family. As a wife and mother, Melissa was unparalleled. Her dedication knew no bounds, and she approached parenthood with an unwavering commitment, from the smallest milestones to significant life events. She stood by our sons, Adam, Aiden, Justin, and Axel, with a radiance of pride and joy. at both Rainbow Land, KlLLER Academy, and Stella Maris Prep. Her love for them was a driving force that shaped the very core of her existence. Melissa's faith in God was the bedrock of her life, providing strength and solace through life's peaks and valleys. As we face a future without her presence, my determination strengthens to nurture and pass on the spiritual legacy to our sons. Beyond her immediate family, Melissa shared an inseparable bond with her mother, Leslie. Their connection just radiated with love and compassion and understanding. As I strive to honor Melissa's memory, I hold close the lessons of compassion, support, and unwavering love that she embodied. Melissa, your legacy isn't confined to the walls of our home. It ripples through the interconnected web of relationships and love you so beautifully cultivated. Your memory remains a comforting beacon of inspiration and enduring love for us all. As we navigate the void left by your absence, your physical absence, I am committed to carrying forward the flame of your love, ensuring that your legacy flourishes in the hearts of our sons and the countless lives you touched. And as is written by Aristotle, he said, "We are what we repeatedly do. Excellence, then, is not an act, but a habit." This was Melissa. Professional realm, finding her place at Petrojam as a chemical engineer. Her talents, however, extended beyond the technical realm. She possessed a natural flair for planning and logistics that would become the hallmark of her career. Even after leaving Petrojam, Melissa continued to navigate the business world with her mother, Leslie, showcasing valor, resilience, and an unparalleled work ethic. Melissa's aspirations were not confined
So I was saying that tribute was written by Jolyan Silvera. And bear in mind, I'm checking on the live feed. Let me show you what is happening as far as the live feed is concerned. Let me show you what is happening. We are still waiting. We'll begin shortly. Please stand by. You see that? So let me refresh the page. Nothing has started as yet. So still waiting on it. But the funeral service or the Thanksgiving service for Melissa was held call it a month after it was known that Melissa was murdered, or known to the wider public, I should say. Because Jolyan himself would have known, say, she was murdered. But it was, the funeral service was held about a month after the postmortem result came out. Jolyan wrote the speech, gave it to his mother. You could have said she was struggling to read it because deep down in her mind, but now mix her up in the thing, but deep down in her mind, based on all that was happening around her, I am sure she must be wondering if her son involved. And the man write a piece of speech there, a piece of tribute, And, you really have to wonder how she feel, Mel Fletcher. You really have to wonder how she feel reading it, knowing that it was being said that she was killed, and knowing that, even though the liar did say, nothing, he's not a suspect. Persons were looking and said, no, he has something to do with this. And eventually, about 4 days after the funeral, or 6 days, because the service was January 12th, 2024, and he was taken into custody by the weekend. But why? We still await. I want to show you some scenes from the funeral, That's the funeral, the Thanksgiving service. And persons were out. Mr. Patterson wrote a tribute and sent it. And if you listen, TBJ news report had said, Mr. Patterson did not call Jolyan's name in the tribute. Well, yes, they have professional writers, Marvally. Jolyan, no, don't boy, no, Marvally. Jolyan, no, don't say no. Who is this calling me? 1 second. Jolyan, no, don't, But let me just check back on the page. Okay. Boy, I'm getting so much videos about Mr. Chinaman who take out him own self. His gun found in the car and all these things. Getting all kinda. Just checking on my phone. See me get another video. Let me see this one. All right, this what? Let me see when I win this something. This take place late last night. Okay, late last night. Still await. Where's Emily await too? Everybody await. Where's Emily waiting on her jar? It not start yet. Hey, no, it not start yet. It not start yet. TVJ await. Nationwide I wait. CVM, go ahead nothing. But everybody I wait. Everybody I wait. But I wonder why Mr. Chin in a Westmoreland really taking one life, sir. I wonder why. It's true, Sir Papa, the young lady died. Yeah, man, I got it early. Yes, so soul flow wait too. Everybody I wait. Yes, everybody I wait. Nothing as yet. Big up soul flow, big up soul flow, big up. Everybody I wait, man. Everybody I wait. Everybody I wait. People don't talk. Papa, people don't talk. Me have to take me leave now. Chan, all right, what good here? We there wait and we say they not started. The young girl say, we'll start shortly, stand by. They not start yet neither. But we are wait. We still are wait. Still waiting. Let me go back and listen to some of what my friend Diane had to say. Diane Jackson Miller. Let me just go back and listen to some more of what she had to say.
For him to hide it, but nonetheless, that's a big difference between the two cases. Now, the sentencing judge started at the usual starting point for manslaughter according to the sentencing guidelines, which is 7 years. But the Court of Appeal said, no, not appropriate, too low. The Court of Appeal said we're of the view that the starting point of 7 years was not appropriate for the particular circumstances of the present case. The applicant shot the deceased with whom he had been having an intimate relationship 5 times in her head with his licensed firearms. The injuries were described as cranial cerebral injuries and multiple gunshot wounds to the face.
I don't know much of you remember the case that Diane was talking about, but there was video, the video. The guy and the female were sitting in an office. The guy was a senior person at the workplace. The female was one of the line staff. And she said something to him. And you could see on the video, the guy just pull him gun and just start put on gunshot on her. You know? She said something. And the guy just start full of bullets. I don't know much I remember that case. And the one in Westmoreland, where I was reading about in the Gleaner a while ago. What the guy named? Somebody call the number, man. The guy in Westmoreland where I was reading about the case. In this, somebody call. That guy, I remember that case, the girl was, I think, 14 years old. I remember which school she used to attend. But he was involved with the girl. He used to run a photography studio, a photograph studio in Sav. And he actually got involved with her, got her pregnant, and him decides say him a kill her. And yeah, man, from school she used to go. Ramon, yeah, used to go from school. Let me just check on the page. I don't want to miss nothing as it starts, Nothing as yet. And I know that guy very well, I used to go up at Petersfield, up at my friend Mike. Used to have a... Let me just send a person a message. Let me just send a person. You need to stop calling the phone, yeah? You need to stop calling the phone. Let me just send this person a message. I don't want to hear the message. Hold on. Let me check again. Let me check again. Still waiting. Or nothing as yet. Yeah, man, that guy killed the female over in Westmoreland. She was a from school girl, got her pregnant, and in this side, same kill her. But let's listen some more of what Diane had to say. Listen to this.
Yes, the intrinsic serious nature of this offense would require a starting point at the higher end of the scale. We thought a starting point of 15 years would be more appropriate, taking into consideration the applicant's culpability and the harm caused. So you see the similarities here with the Silvera case. Intimate relationship, well, in the Silvera case, they were actually married. He shot her 3 times with his licensed firearm. This case, the Broomfield case, is really good authority that will allow the sentencing judge to go much higher than the 7 years. That is a general starting point. Now, the trial judge had looked at what she said were the aggravating factors in the Broomfield case. Prevalence of this type of crime in society, we're going to see the same in the Silvera case. The deceased was a girlfriend of the applicant, intimate partner, so that amounted, she said, to intimate partner violence. Same with the Silvera case, except they were married. A life was lost. That's what the sentencing judge said. The Court of Appeal said, no, this is not an aggravating factor. It should have been looked at as an indication of the seriousness of the offense to determine the starting point. I don't see how that affects the starting point, because by definition, manslaughter means a life lost. So that alone would take you to the usual starting point. I don't see how that would increase the starting point. The sentencing judge also said the deceased was shot and killed at her workplace in the presence of a co-worker. Compare that to Melissa Silvera, who was shot and killed in her home where 2 young children were. Again, I just think that's much worse. Now, the Court of Appeal added that they considered his age, Broomfield was 32 years, to be an aggravating factor because of his maturity. So they said these aggravating factors would increase the sentence from the starting point of 15 to 23 years. So they started at 15 years, then they added on 8 years for the aggravating factors, and then they said they reduced that to 20 years because of the mitigating factors. Then they said that the sentencing judge had used a discount of 10% for his guilty plea, and they said they weren't going to trouble that. So they arrived, therefore, at 18 years. Now, just to make the important point here, that he pleaded guilty, Broomfield, at the earliest possible date. So he could have got a discount on sentence of up to 50%. But because of the circumstances of the case, the sentencing judge said she was only giving 10% discount, and the Court of Appeal agreed with that. In the case of Silvera, he pleaded guilty before the trial started. So he could potentially get a discount of up to 35%. But when we look at the Broomfield case, I think we're also not going to see the full discount given. I would say they probably will use about the same 10%. And that is because of the seriously aggravating factors in the case. In terms of the mitigating factors that the judge looked at in the Broomfield case, remorse of the applicant, and trust me, we're going here, Silvera is remorseful. Trust me.
(21 to 26 and 31 and 32). This I recall to my mind
Good morning. Melissa, the boy mom. Have you ever read the meaning of a word in the dictionary and then seen it so embodied fully in real life? The definition of indomitable is impossible to subdue or defeat. We, the boy moms, witnessed that fighting spirit firsthand. She sought to give her children the best of everything she could. She was laser focused on their future and the foundation that she wanted to lay. Even as she experienced the incredible loss of her angel baby, a loss that would render most unable to function, and the trials of her mother's illness and subsequent passing, somehow she was not deterred. She never took her eyes off the goals, the best education, and if she felt they needed additional to the lessons at school, she became the teacher herself. The best in sport, swimming, football, tennis, you name it, she found it.
My viewers and subscribers, please hit on the like button, because when you do that, we are gonna be catching the video, the sentencing phase as it starts. We not make you miss anything, but the more you hit on the like button, is the more YouTube send us out so other people can come and join. Because we know a lot of people want to see what is happening. But keep on listening to some of the tributes that were paid at Melissa's Thanksgiving. Listen.
The best activities to identify their gifts and talents, chess, taekwondo, that's what Melissa sought for her boys, and talents and gifts they have. Watch these boys and how they perform in everything they attempt. She honed their talents. She taught them about excellence. She found the coaches. She drove them back and forth. She encouraged them. She pushed them to be their best, and she cheered them from the sidelines. Although her body is now at rest, her spirit continues to fight. Every time Adam, Aiden, and Axel come to your minds, it's Melissa's fighting spirit. Listen when she calls. Do what you can to give them love in honor of the indomitable spirit that was Melissa. Melissa was. Excuse my voice. Those are two words that I had never imagined using in this context today. You see, in our frequent conversations, the vibrancy, effervescence, brilliance, determination, and warmth that I experienced in her presence was so potent, whether in person or on the phone, that I could never imagine my life without it. The summer of 2018 marked a significant milestone in our lives as mothers. Unknowingly to us, at the time, a sisterhood was born, a bond between mothers who had one of the most important roles in our society today, that of raising sons, the men of tomorrow. For Melissa, her sons were more than just her priority. They were her legacy, as she would say in our frequent talks. Adam, Aiden, and Axel were her motivation for everything she did in life. There was only one standard for Melissa: excellence, which she demonstrated not only for her family, but for her friends as well. I'll give you an example. On Melissa's birthday in September of last year, I decided that I was going to plan a birthday brunch for her at my home. As mothers, we often put the needs of our families above ourselves, and Melissa was no exception. I wanted her birthday to be all about her. I served delicious pastries, fruits, and cocktails. But Melissa, even on her special day, couldn't just sit and receive all that was being done for her. She said, "Lace, we have sweet, but we don't have savory. I'm going to make an omelette." And so, using the ingredients from my fridge, Melissa made the most delicious omelette I've ever consumed. But that was just the kind of person she was to everyone who had the privilege to get to know her. I am grateful for the time we shared. Today, we mourn the loss of Melissa, our dear friend, our sister. We will miss you.
My dearest Melissa, I could not have imagined writing this dedication to you. In fact, words will never give justice to the amazing woman you were. We bonded over the loss of our mothers that led to a special sisterhood. We often spoke about how strong, supportive, and protective our mothers were, and it helped us as we maneuvered through our own motherhood journey. From the countless play dates we did to keep our sanity during the summers, the holiday parties, gift exchanges with the children, to school runs, it was truly special doing it all alongside with you, my friend. I am truly missing you, my beautiful, intellectual, and sophisticated friend. I pray that you are at rest. Your boys will forever have a guardian angel. Melissa, our boy mom group will never be the same. We will forever love and continue to miss you. A part of our puzzle is gone forever. But we will never forget you. Our hearts are broken. But in our brokenness, we will do our best and do what moms do. We will pick up the pieces. Cheers to your memories, our dear friend and sister. Fly high and soar with the angels. You will remain in our hearts forever.
My brothers and sisters, good morning. May I invite you to take out the cell phones again and attend to them. We still hear them ringing and it's disturbing the whole broadcast, okay? Thank you, God bless you.
And you notice, none of the females, none of the women look over wife killer side, because like I tell you before, everybody knew that are suspected that he was his wife's killer. And that day, at this sermon, boy, I can tell you, may I tell you, I tell you. But we're still waiting. Let me review refresh the page again. And Nationwide is confirming what I had said before when I broke the news not too long ago, that Dacia has died whilst undergoing treatment. There she is. Nationwide news understand that Dacia Forrester, the woman, burnt during a fight with another woman at a gas station in Witham, Westmoreland, has died. It is understood that she died last night while undergoing treatment at hospital. Dacia suffered third degree burns. Over 70% of her body, and has been in hospital since the incident, which took place Thursday, February 19. Reports are that Dacia and her sister, they went to the gas station and confronted a pump attendant. During the altercation, she was doused with a flammable substance. She later became engulfed in flames. Bystanders reportedly extinguished the flames and rushed with her to hospital. The pump attendant, 30-year-old Colette Swaby of Old Road, Witham, has been charged with assault occasioning grievous bodily harm. They have assault occasioning, but grievous bodily harm in relation to the incident. Dacia's family previously told Nationwide that they believe the public has been unfair in its judgment of the incident and criticism of Dacia. Well, if being truthful means being unfair, it means that Papaya one of them who was being unfair. If being truthful means being unfair, or that's what you interpret it to means, it means because, like I said, all of this could have been prevented. No, never want her to burn up neither, never want her to burn up. But I am saying it could have been prevented. If only when she left the gas station, she did stay away and not come back with her sister. And because we are saying what we are saying now, people are saying we are being unfair. No, we have to talk the truth. It's the truth we are talking, you know, nothing else. If she had stayed away, he wouldn't reach this point. He would not reach this point. You know? No one ever want her to die, Natisha. Never. Would I never want her to get burned up neither. Would I never ever wish that on anybody. You know? But we have to learn from things like these, you know. We have to learn from things like these. And you see, for every action, there's a reaction. And whenever something happens, and people are going to talk the truth, and you are going to cuss and say this and that, all you can do a cuss. But you can't say we are being unfair. You can't say this. But you can't say we are telling a lie. Look at wicked man, no? Look for wickedness. Look at wickedness. Let me check by the page. Nothing as yet. It's now box cover. It is now 11:32. Chief Justice have we are whole out, man. So apparently they are still going over the reports. They are still going over the reports, the antecedent, all of these things before the judge pass sentence. And only one man, you know, the Chief Justice of Jamaica, you know, only him alone can decide on the sentence where I'm going to pass. One of the things that the law provides for now, you know, there can still be an appeal if the DPP is not satisfied with the sentence today. She can file an appeal, and don't think so because of the Chief Justice. The Court of Appeal cannot overrule. This cannot override the Chief Justice sentence. The Court of Appeal can. So the DPP can appeal. Faithful. We don't call people names over here, so you can say it, but I'm not gonna say it. The Chief Justice can pass a sentence. The DPP can appeal it. The Court of Appeal can either agree or disagree. It seems as if them plan to start, you know. Hold on there. Seems like them plan to start. I don't want to miss a minute. So hold on a bit. Let me catch this. Oh yeah, so them are count down to some second. Oh yeah, say. They are counting down. 15 minutes time, so they're going to start. They are going to be starting in 15 minutes time. So, then they are going to be starting in Papa, I asked that question and they said, no, of course it can appeal. The DPP can appeal the sentence if she think it is too low or too little bit. Remember that there was a guy from Westmoreland, who he was in the anti-gang, whatever, and the judge in Hanover, the case was tried in Hanover, and the judge gave him a little bit of sentence. And it was appealed, and the Court of Appeal overruled the sentence that the judge passed and give him a higher sentence. And if the sentence is, according to the defense, is too high, his lawyers, Peter Champagne is his lawyer now, but if a lawyer can appeal the sentence on his behalf, it never used to go so before, but it can go so now. The DPP can appeal the sentence, and if in her mind she think it is too low. All right, so they have what, 13 minutes left? All right, let's go back and look a little bit more on the funeral and the Thanksgiving service. And look at wicked man, wicked man Jolyan, wife killer. Oh, the mother is gonna get up next. I want to move on a little bit and see what happened after her. I didn't watch everything, you know. Don't want no song in it. What Jolyan? Look at Jolyan. Why I tell you, you know. I tell you, it's what 13 minutes left. I wanted them to start on time based on the stopwatch. I must the Chief Justice tell them to put on the stopwatch, you know. So let's hope, let's see. Because this one now is what we have been here almost 2 hours now. What you say? How so long? How so long we there? A 2 hour now we there, you know. You realize 2 hour water. Yes, watch him a smile, no? Watch him. Watch him. Why I tell you. You say you're concerned about the boys, Natisha. Okay. Why? Have to be. Have to be. Growing up knowing that mommy killed daddy, and they were the ones who found mommy alive, mommy dead. Sorry about that. They were the ones who discovered mommy, and they would have called daddy and see how daddy was reacting. So we have to be concerned about them, yes? Have to be. Have to be concerned about them. We have what, 11 minutes to go now? The stopwatch is saying 11, still counting down. 1 second.
From the love of God in Christ Jesus our Lord. If we live to the Lord. And if we die to the Lord. So then, whether we live or whether we die, we are the Lord's. For to this end Christ died and lived again, that he might be Lord both of the dead and of the living. We brought nothing into this world, and it is certain we can carry nothing out. The Lord gives, the Lord takes away. Blessed be the name of the Lord. Blessed are the dead who die in the Lord. Even so said the Spirit, for they rest from their labors. With faith in Jesus Christ, we receive the body of our sister Melissa for burial. Our sister was washed in holy baptism and anointed with the Holy Spirit. Let us therefore with confidence pray to God our Heavenly Father, the giver of life, that he will raise her to perfection in the company of the saints. I bless the body of our sister Melissa with holy water that recalls her baptism, of which St. Paul writes, all of us who were baptized into Christ Jesus were baptized into his death. By baptism in his death, we were buried together with him, so that, just as Christ was raised from the dead by the glory of the Father, we too might live a new life. For if we have been united with him by likeness to his death, so shall we be united with him by likeness to his resurrection. On the day of her baptism, Melissa was incorporated into Christ. On the day of Christ's coming, may she be clothed with glory. The Lord be with you.
And also with you.
Let us pray. O God of grace and glory, we remember before you this day our sister Melissa. We thank you for giving her to us, her family and friends, to know and love as a companion on our earthly pilgrimage. In your boundless compassion, console us who mourn. Give us faith to see in death the gate of eternal life, so that in quiet confidence.
We are still here, people. We are still here. The clock is counting down at the gun court. The clock is counting down. Less than, let me see how much minutes now. Less than 7 minutes to go. When it's 2 minutes to go, I'm gonna go over the link, and because we don't want to miss a beat. So let's keep watching a part of Melissa's Thanksgiving service. Keep on watching. And you can watch the entire video over at Dennis Duncan Streaming. See it at the bottom of the page there? You can watch it over there.
Confidence, we may continue our course on earth until by your call we are reunited with those who have gone before, through Jesus Christ our Lord.
Amen.
Amen.
When it comes down to YouTube, we have to be careful when it comes on to music. When you say a priest sporting a dreadlocks hairstyle, yeah, man, we're wrong with that. Render your heart. It's about the heart, you know. It's about the heart, you know. Let us fast forward a bit and see. Let's fast forward a bit. Scripture reading taking place now.
Reading is taken from the letter of Paul to the Romans, chapter 8, verses 31 to 39.
Let's go forward and see. When you come on to YouTube, we have to be careful with the music, you know. But we are what? 4.5 minutes to go, based on the counting clock, the countdown clock. 4.5 minutes to go. So we are watching. You're not missing anything as far as the sentencing is concerned. The live stream not started yet. They are still counting down. But we are still waiting.
Jesus said, "Do not let your hearts be troubled. Believe in God, believe also in me. In my Father's house there are many dwelling places. If it were not so, would I have told you that I go to prepare a place for you? And if I go and prepare a place for you, I will come again and will take you to myself, so that where I am, there you may be also. and you know the place where I am going. Thomas said to him, Lord, we do not know where you are going. How can we know the way? Jesus said to him, I am the way and the truth and the life. No one comes to the Father except through me. Peace I leave with you. My peace I give to you. I do not give to you as the world gives. Do not let your hearts be troubled, and do not let them be afraid. This is the gospel of Christ.
Praise Christ. Alle.
So I think we are now under 2 minutes. So I'm gonna go over to the judiciary's page and count down with them and see if they are gonna be starting at the time. Let's see if they're gonna be starting at. Let's see if they're gonna be starting in a minute, as is on the screen. Let me make sure we have my volume set up or my volume up. So we are counting down. We are counting down. And my viewers and my subscribers, just close the chat a little bit. Close the chat a little bit and hit on the love button. Hit on the thumbs up button because the time is at hand. I want people to know so we are over here and we are streaming this live. We want people to come and join. So just close the chat a little bit and then you hit on the thumbs up button. Let's see if they're going to be starting at the time they said they're going to be starting. It's closing down. You can count along. 35 going down. Just close the chat a little bit and hit on the thumbs up button. Right? Hit on the thumbs up button so that YouTube can send it out so people can know, say, we're over here. All right? 15, 40. Let's hope because Mr. Chief Justice, Mr. Sykes, we are waiting long enough. We have been waiting long enough. 2, 1, 0. We are waiting. We still are waiting. We are still waiting. We are still waiting. And no, in a pause, it is still playing. They're not starting yet. We still are waiting. We are still waiting. All we are waiting. Almost 2,000 are waiting. But if it's almost 2,000 people, let me see how much thumbs up we have here. We are over 1,800 now. So apparently people are hitting the thumbs up so people are aware that we're over here. So people are aware. But we don't reach 1,000. We don't reach 1,000 yet. Come on, people. Hit on the thumbs up button. Hit on the thumbs up button. Hit on the thumbs up button. We don't reach. Huh? Hit on the thumbs up button, man, so people can know so we over here. We are now what? 885? We reach 1,000 now. Okay. That was quick. Yeah, man. We still are waiting now. All of us waiting same way. What you are seeing on the screen is what is actually on the screen. We no pass nothing. Well, them gone back to that now. They gone back to will begin shortly. Stand by. So they are going back to that. We still await. We are still waiting. We are still waiting. Going back to will begin shortly.
O Lord Yahweh, draw us closer to yourself and keep us still so that we may know your will. O Lord Yahweh Adonai, touch our hearts and calm all our anxieties.
We are still waiting,
and keep us still.
We are still waiting, people, and you're not missing anything. We are still waiting, and we have no control over what is happening, but we are still waiting. All right? So let's watch some more of the service until we get the go ahead.
So that we may know your will. In the name of the loving, living, and liberating God, Father, Son, and Holy Spirit.
Amen.
Amen. Let us be seated. We have come today to celebrate the life of a mother and a daughter. We have come to celebrate the life of a disciple of Jesus. We have come to celebrate one who proclaimed the Christian faith. We come as children of the baptized community, the community of faith. We are all joined together through baptism. Baptism in which water has been poured on us. The cross was scarred on our foreheads as we were named Father, Son, and Holy Spirit. Please pardon the traffic of our retreat. They constantly provide competition with the sermon. Beloved, we come as a baptized community, the community in which we proclaim the Christ who was raised for us, crucified and raised in order to give us a sense of purpose and meaning. In the gospel we heard, there is a point in the text that Jesus proclaimed, which we are to listen to today. In that narrative from John 14, verses 1 to 6,
Let's see.
Thank you very much for joining us this morning.
So here we are, gentle people. Let's go.
Begin. No.
Okay, these are the sentencing remarks in the matter of the King against Jolyan Silvera, charged on an indictment containing 2 counts. Count 1 charges him with the offense of using a firearm to commit a felony, contrary to section 14(2) or section 14 subsection 2 of the Firearms Prohibition, Restriction, and Regulation Act. The particulars of that offense are that Jolyan Silvera, between the night of November 10, 2023, and the morning of November 11, 2023, in the parish of St. Andrew, used a firearm to commit a felony. Initially, the felony was murder. It was changed to manslaughter, and he pleaded guilty to that offense. Count 2, charge him with the offense of murder. Particulars of that offense are that Jolyan Silvera, between the night of November 10, 2023, and the morning of November 11, 2023, in the parish of St. Andrew, murdered Melissa Silvera. To that count, he entered a plea of not guilty of murder, but guilty of manslaughter. The plea was accepted by the prosecution and accepted by the court. This plea was entered on February 3, 2026. And on that date, a statement from the defendant was read into the record. And it states, I, Jolyan Silvera, made this statement to say that on the night of November 10th, 2023, a very unfortunate incident occurred, resulting in the death of my wife, Melissa Walter Silvera. Leading up to that event, there has been provocation from her ever since the death of my son, for which she continues to blame me. As per usual, to avoid confrontation, these confrontations vary from financial to taking responsibility for the conditions that we were living in, and she has a time where she explodes no matter when and where. She became very physical that particular night. These are ongoing things. So at times, when I see that this is going to blow out of proportion, I normally take refuge, thank you, at my sister's house to allow her temper to quell. On this particular night, the rhetoric began. She became more confrontational than normal, screaming, shouting, and even at times swinging her fist. So I decided that it was time to leave. So I reached for my gun, where it is normally kept, to holster it, and told her that I would be back tomorrow. She became increasingly angered and enraged, and lunged after me and grabbed at the gun, and then uttered the words to the effect that I was responsible for the death of our child and made derogatory comments about my mother and the family. Although she had mentioned blaming me for the death of my son before that night, the way she said it and how, and the mention of my mom and my other family, her words and expletives that night really angered me in the moment. Melissa told me I must stop fucking my sister because every night I'm always going to my sister's house and a sister can't do what a wife can do. She said that my mother was a selfish fucking bitch and maybe I should go and fuck her too. These words provoked me, and her final comments were enough to fling the rest of the picnic them in the pool and kill them too. With all of these words, I lost control and fired. It was never my intention to do this. It was not premeditated, and it was not my intention to hurt or kill her that night. This having happened, I panicked and I left. Over the course of the next few days, I thought about my children losing two parents and thought it best not to admit because I wanted to be there for them. And importantly, this statement, which I read over, consisting of what? One page signed by me, Jolyan Silvera, is made of my own account. And it went on to indicate that it bore his signature and date and a witness who was not connected to the matter. So what we have then is a written statement in which he outlined in some detail the circumstances that unfolded on that unfortunate evening. Now let us go now to what the prosecution outlined to the court. And then we'll have some observations about that, and then put this in context of the law relating to homicide. Prosecution's narrative is this. Sometime after 10:30 p.m. on the 10th of November 2023, Mr. Silvera told his wife and children that he was leaving and that he will return the following day. His wife told him that he could not leave, and an argument ensued. According to the children, the adults swore at each other and then he left. Sometime before 6 a.m. on the morning of the 11th of November 2023, one of the children, and the name is there, but I'm not calling the name, went into his parents' room. He discovered his mother's lifeless body on the floor next to her bed. He observed that blood was coming through the coat, her butt, mouth, and nose. he ran from the bedroom and alerted his other brother, who accompanied him back to the parents' room. They indicated they both checked for signs of life. They then decided to make contact with their father and were eventually successful. The prosecution next referred to a witness statement provided by Mr. Silvera. This is a statement that was provided before he became a suspect. In that statement, he indicated that upon speaking to his children, he contacted the Stony Hill police station and told them that he was on his way home when he got a call from his son indicating that his mother's lifeless body was there and that he needed assistance. Upon arrival at the house at 28 Diamond Road, Stony Hill in the parish of St. Andrew, Mr. Silvera went into his bedroom, saw his wife sitting in a position with her head leaning forward at the side of the bed. According to witnesses, that is the children who were there, he touched her, spoke to her, and found that she was not responding. So up to that point, based upon this, you had the body, the children, then Mr. Silvera arriving, then you had Mr. Silvera, the body, and the children. Short while after, a first responder from the Jamaica Constabulary Force arrived, that is a sergeant from the Stony Hill Police Station. He went into the bedroom along with Mr. Silvera, where he, the police officer, saw the body of the deceased. The police officer described the body as being on her knees in a crouching position with her face lying on the floor. The police officer then took a photograph of the body, and whilst he did so, he says Mr. Silvera cried out. He told Mr. Silvera to cover the nude section of his wife's body. The police officer did not carry out any further examination of the body. The officer indicates that he did not, that Mr. Silvera advised him that the deceased had no known medical condition, and the police officer seems to be indicating that a post-mortem examination would be conducted to determine the cause of death. The House of Tranquility Funeral Home was contacted for the removal of the deceased body. Not clear from the narrative who did the contacting, but nonetheless, that was a contact that was made. The police officer says he then indicated that he told Mr. Silvera, do not do anything to the bedroom pending the post-mortem examination, as the cause of death was undetermined. Mrs. Silvera's body was removed and taken to the House of Tranquility Funeral Home. A post-mortem examination was scheduled for the 1st of December 2023. The pathologist who arrived to do the post-mortem examination observed marks on the body. As a result of her observation, the body was sealed and the detectives were called to assist in the investigation. So, on the 15th of December 2023, the same pathologist conducted post-mortem examination on the body of Mrs. Silvera. The pathologist noted that there were 3 gunshot wounds, 1 perforating gunshot wound to the front right thigh, 1 penetrating gunshot wound to the left side of the lower abdomen, and the 3rd that is described as a superficial penetrating gunshot wound to the right side of the lower abdomen. The pathologist found that the immediate cause of death was due to multiple gunshot wounds. During the post-mortem, the pathologist removed 2 projectiles from the body of Mrs. Silvera. These projectiles were handed over to an officer, not the one who turned up apparently on the 10th of November, assigned to the Jamaica Constabulary Force. And it was after the post-mortem was concluded, Mr. Silvera became a suspect and was taken into custody. The narrative goes on to indicate that he's a licensed firearm holder. Specifically, he has a 9mm Glock Model 17 Gen 4 double action auto-loading pistol black polymer receiver slide, a 17 cartridge capacity magazine bearing the serial number AAFZ038, and this firearm was taken from him. The firearm was submitted to the Institute of Forensic Science and Legal Medicine for ballistic testing, along with the 2 projectiles removed from the body of the deceased. The ballistic examiner made a comparison. He test fired the gun. This is now in January of 2024. Test fired the gun. He took results from those test fires of January 2024 and compared it to the projectiles that were removed from the deceased body. He found what he called level 1 characteristics matching. That is, according to the narrative, the projectile came from a Glock pistol, the type of Glock that it would have come from. He found that there was some amount of level 2 matching, and this apparently is striations, and that there were no additional markings that were unusual. So I'll pause here for a moment and indicate this. In preparing for this matter, I was reading through the material, and I had sent questions to both counsel for the Crown and the defense through the Registrar of the Supreme Court to answer specific questions. I had used the incorrect expression. I think I used markings, level 1 markings are not matching. So counsel for the defense, being the cautious man that he is, he indicated that he did not have any document that referred to level 1 or level 2 markings. So that was my error. They should have been matching. The Crown also responded, getting assistance from Superintendent of Police Miguel Bernard, and he responded, and apparently this is a quotation from him. I don't think the defense is taking issue with the exposition on this by the superintendent. He says, correcting me, that the term used was level 1 matching and level 2 matching. The term is used to provide a simplified understanding of the examination process. Level 1 matching, this is matching of the class characteristics. Class characteristics can be used to eliminate certain firearms as potential sources of firing a bullet or a cartridge case. However, they do not narrow it down to one specific firearm in the class or group. Class characteristics of bullets include the caliber, the number of lands and grooves, direction of twist of lands and grooves, and width of the lands and grooves. It says in this case of the King against Jolyan Silvera, the class characteristics narrowed the source of the marks on the bullet to Glock pistols, which is a smaller group from all the potential make of firearms that exist. The accused firearm submitted as evidence in the case was a Glock pistol. Therefore, the examination progressed to level 2 examination. So what he seems to be saying is that the level 1 determines the class. And then once it falls, you identify the class, then you go on now to see about the specifics of the object, the gun. Level 2 matching, he says, is this. This is matching of the individual characteristics that are unique to one specific firearm. At this level, the comparison requires microscopic analysis and cannot be done with the naked eye. Individual characteristics of bullets are random, striated marks, striations on the land impressions on the bullets. In this case, the King against Jolyan Silvera, there was sufficient matching of the individual characteristics to conclude that the bullets matched the test fires said to be from the accused's licensed firearm. He says the damage seen in the barrel was consistent with a corrosive chemical reaction in the barrel, was unlikely to have occurred naturally because in the relatively short space of time between the death of the deceased Melissa Silvera and the gun being submitted to the ballistics department, this corrosion distorted the individual characteristics, making it difficult to match bullets fired through the barrel before the corrosion and those that were fired through the barrel after the corrosion. That is to say, the damage was consistent with or likely a deliberate attempt to prevent any subsequent matching of test fires from the gun with any bullets that were fired through the barrel prior to the corrosion. So we go back now to the narrative here. Yes, so he continues now. There is something called an IBIS system, that is an integrated ballistic identification system, commonly known as IBIS. This is a database, and this database contains firearm ballistic signatures. So how does this come about? Under the Firearm Prohibition, Restriction and Regulation Act that came into effect in 2022, roughly a year before this incident, Section 20 of the legislation sets out the responsibilities of what is called the Firearm Licensing Authority. Section 20, subsection 1 says, there shall be established for the purposes of this act a body to be known as a Firearm Licensing Authority, which shall be a body corporate to which Section 28 of the Interpretation Act applies. Section 20, subsection 3 states, the authority shall be responsible for regulating, in accordance with this act, the handling of firearms and ammunition, and the importation and exportation of firearms and ammunition into or from Jamaica, and without prejudice to the generality of the foregoing, the functions of the authority shall include, and it has an impressively long list, but for our purposes now, we come to paragraph L, which says that that is the Firearm Licensing Authority to conduct ballistic testing, capturing ballistic signatures in relation to privately owned firearms, and capturing related information with respect to firearms that are the subject of authorizations granted by the board. Then there is reference to Section 29, which speaks to the identification of firearms. And then there is Section 31, which says the institute shall be the responsible entity for capturing ballistic signatures and other information in relation to firearms that are the property of the government of Jamaica. And then Section 31, subsection 2 says the authority shall be the responsible entity for capturing ballistic signatures and other information relating to privately owned firearms. So that is the context in which this capturing of signatures of firearms take place. An institute is defined in the legislation as the Institute of Forensic Science and Legal Medicine. That's found in Section 2, that's the interpretation section of the statute that defines institute. So that is what is being referred to in the legislation at Section 31. Right, so now, so the narrative goes on. The Firearm Licensing Authority apparently has access to this IBIS database. And apparently the idea is that whenever a person would acquire a firearm that's a private citizen and present the firearm to the Firearm Licensing Authority, test fires will be made and the ballistic signature from the said firearm is uploaded to the IBIS system. So the FLA creates a signature, is stored on the IBIS system. The expert goes on to say now that in January 2024, he took the test fires from Mr. Silvera's firearm and compared it to the ballistic signature that the FLA would have had based upon its statutory powers. And he also compared the projectiles taken from the body of the deceased to the ballistic signature of Mr. Silvera's firearm containing on the IBIS database, and he got a match. This led him now to do a physical examination of the ballistic material. So the expert contacted the Firearm Licensing Authority and requested the physical ballistic material belonging to Mr. Silvera's Glock pistol. The FLA provided the material to the Institute of Forensic Science and Legal Medicine. The expert did a comparison, and the spent casings in the FLA's possession that came from Mr. Silvera's firearm was compared against the projectiles, that is the bullets taken from the body of the deceased, and it was a match. He went further. He did a comparison as well between the spent casing, that is the ballistic material from the FLA, to the test fires that the ballistic expert, did of Mr. Silvera's firearm in January of 2024, and arrived at the same conclusion. That is, he saw level 1 matching and some amount of level 2 matching. The expert goes on to say, according to the Crown, having looked at the barrel of the firearm closely, he saw what in his opinion would have been the existence of corrosion or the existence of a corrosive material being introduced into the barrel of the firearm. But based on the extent of the level 2 matching of the characteristics, he was able to say that these projectiles came from this firearm. Now, additional narrative here. The Crown outlined that each time an individual renews his or her license for the firearm, the authority itself would take the firearm and inspect it for modifications or any signs of tampering. The narrative from the Crown is that on the 29th of September 2023, Mr. Silvera renewed his license and the firearm was inspected on that day. The information from the Firearm Licensing Authority is that no signs of tampering were observed during that inspection. And then, after the conclusion of the ballistic examination, no surprises here, Mr. Silvera was taken into custody. I think he was already in custody before, based upon the narrative, but anyway, he was now arrested and charged. The expert expressed the view that the corrosion could not have occurred naturally based on what he saw. In fact, he said that that type of corrosion would normally occur in firearms that are kept in water or firearms that are buried in some areas as frequented by liquid or some other form of substance. He expressed the view that it could not have occurred between the 29th of September 2023, when the firearm was examined by the Firearm Licensing Authority, and January 2024, when he, the expert, did his examination. So he was then, that is Mr. Silvera, arrested, charged for the offenses of using a firearm to commit a felony and murder. And after that narrative was outlined, then the Crown indicated that they were minded to accept the plea. So that's part one of my remarks. So now, let us put things in perspective. The legislation that governs offenses of this nature is the Offenses Against the Person Act. At Section 6, it says, and I'm missing the first few letters here. So let's find one with all the information present. Section 6 says, where on a charge of murder, there is evidence on which the jury can find that the person charged was provoked, whether by things done or by things said, or by both together, to lose his self-control, the question whether the provocation was enough to make a reasonable man do as he did shall be left to be determined by the jury. And in determining that question, the jury shall take into account everything done and said according to the effect which, in their opinion, it would have on a reasonable man. You have to forgive the gender of the language, but that was the language of the statute at the time. It applies to both men and women. So the point is that what Mr. Silvera outlined in his statement, had it gone to trial, would have to be put to the jury for them to consider whether he is not guilty of murder, but guilty of manslaughter. And let us not forget that in the context of a trial, the jury, in its wisdom, can acquit completely, because we seem to forget at times that juries don't have to accept any fact that is put to them. They are constantly reminded of this. So a jury, if they analyze the evidence and they conclude that no offense was committed, then they are duty bound to return a verdict of not guilty, because at that point, the only opinion that counts is theirs, not the judges, not counsel for the defense, not counsel for the prosecution. So, having regard to what is in the statement, though he was indicted for murder, the question of manslaughter would have to be left for the consideration of the jury, and they would have been told, among other things, that they cannot convict of murder unless they are sure that provocation or lack of intent or any other factor that will reduce it to manslaughter didn't arise on the case. So now, let us put this in perspective. So manslaughter is best understood if it is seen in the context of homicide. And homicide is a generic term, killing of one human being by another. And in our criminal justice system, homicides are classified as either murder or manslaughter. And I'm excluding, for the purposes of this, death caused by reckless or dangerous driving. So, murder occurs when a person of sound mind and discretion, by a voluntary and deliberate act, causes the death of another who is under the sovereign's peace, in circumstances where the person doing the act causing death had the intention to kill or cause really serious bodily harm, and while doing the act which causes death, there was no lawful justification, such as self-defense, or excuse, such as insanity, and so on. Now, manslaughter falls into two categories: voluntary and involuntary manslaughter. In voluntary manslaughter, all the ingredients of murder are present and would be murder, but for the presence of a partial defense, such as provocation or diminished responsibility. It is voluntary manslaughter because the act which causes death was done deliberately, with the intention to kill, and would be murder had it not been for the presence of the partial defense. Involuntary manslaughter is so called because of the absence of an intent to kill or to cause really serious bodily harm. So into this category, I find things such as unlawful and dangerous acts. You might push over someone or you punch someone in the face and they drop and hit the head and they die. Oftentimes, in that context, the person doing the punching does not intend to kill or to cause any really serious injury, but it's an unlawful act. So that is the distinction, really. And what is the significance of the distinction? It is now reflected in the approach to sentencing. So, manslaughter arising by provocation or by diminished responsibility, into the category of voluntary manslaughter. Manslaughter arising from an unlawful and dangerous act or by gross negligence, involuntary manslaughter. In the case here, we are not dealing with involuntary manslaughter, but voluntary manslaughter. I make reference at this point to the Social Inquiry report, where the defendant was interviewed, and this is what he indicated to the probation officer. Said Mr. Jolyan Silvera was interviewed at the Kingston Central Police lockups. During the interview, he was respectful and cooperative. He stated that for several years prior to the incident, he and his late wife frequently argued, primarily over financial matters. He further disclosed that he was blamed for the death of their son, which further contributed to ongoing tension in the relationship. On the day of the incident, Mr. Silvera reported that an argument occurred between him and his wife. He explained that it was customary for him to leave and spend the night at his sister's residence following disputes. However, during this particular argument, his wife spat in his face and accused him of engaging in incestuous relationships with his older children and his sister. Mr. Silvera stated that during the confrontation, he reached a breaking point. He went to retrieve his licensed firearm to holster it, and as his wife approached him, the situation escalated further, and in the course of the struggle, he discharged the weapon 3 times, fatally wounding her. He admitted that he panicked immediately afterward and left the apartment. He emphasized that the incident was not premeditated, but rather the result of provocation in the heat of the moment. Mr. Silvera expressed deep remorse, stating that he is profoundly regretful that such a tragedy occurred. He acknowledged that there will be consequences to face, but he hopes that one day he will be able to meet his children again to seek their forgiveness. So, Mr. Silvera further explained that no professional intervention was ever sought during the course of their marriage, their marital difficulties. He described his late wife as someone who would escalate quickly during disagreements, going from 0 to 100 in no time. he stated that he often encouraged her to undergo an assessment to determine whether she might have been suffering from a mental health condition such as bipolar disorder. He added that matters worsened following the death of her mother, after which, quoting now, everything that could go wrong went wrong, unquote. And he noted that his wife did not cope well with her mother's passing. So, again, had the matter gone to trial and this information was presented as a part of this case, the question of provocation would have had to have been left for the consideration of the jury. Now, I'll go back to an earlier part of the prosecution narrative before, well, not so much the narrative, but remarks made by prosecuting counsel before getting into the details of the narrative for this specific night. The prosecution did indicate that there was information available to them from someone who had known Mrs. Silvera for a considerable period of time. And that person and Mrs. Silvera would have what she calls tracing, and by tracing, said she meant to make up some noise. The prosecution also had information that Mr. and Mrs. Silvera would often have arguments, but they would call and make up later. And even in that context, the deceased would still push her point. She was very determined and excellent, according to this individual. Indicate that she was a loving mother to her children. And the prosecution also had information that Mrs. Silvera was very mouthy, and what was meant by that is she was feisty and a strong-willed woman who was very smart. So that was information that the prosecution had in its possession, which they indicated to the court. And so that is part of the context now in which the plea for manslaughter to manslaughter was considered by the court. And certainly, in my view, what Mr. Silvera indicated as to how the argument developed is not inconsistent with what these other persons are saying. This is not a question of maligning the dead, but it is what it is. And the information is from persons who are, or some of, at least two of them are friends of the deceased woman and who knew her apparently quite well. So that is the additional information and context here. Now, I'm going further now into the sentencing process. This is now part 3. Sentencing is a complex process. It is a multi-layered and multi-factored process. There are factors relating to the offense itself, which must be considered, and matters relating to the offender, and both interact. And that interaction assists in determining the appropriate sentence. It has also been said that sentencing courts must keep in mind what has been described as the 4 classical principles of sentencing: retribution, deterrence, prevention, rehabilitation. The authorities indicate that the court also needs to keep in mind the character and antecedents of the offender. So, in other words, even if you are dealing with similar offenses, the sentences may not end up to be the same mathematically, because there may be factors that are peculiar to one defendant that do not apply to another defendant, even in the same case if they are convicted for the same offense. The level of participation and culpability may very well vary. So it is not surprising then in some murder cases, several persons can be convicted, but one person may be an accessory before the fact, another may be the one who did the act that caused death, and so on. So you have the variations there. Now, for voluntary manslaughter, which is what we are dealing with here, it usually attracts a custodial sentence, and the custodial sentence frequently, not invariably, frequently is higher than the sentence for involuntary manslaughter, if for no other reason that voluntary manslaughter is closer to murder in the criminal calendar. So that is how the reasoning goes. Remember that voluntary manslaughter involves an intention to kill or cause serious bodily harm and would be murder but for the presence of the partial defense, as in this case of provocation. It is also a serious violation of the victim's right to life. And so, for those reasons, it attracts a custodial sentence. The Criminal Justice Reform Act tells us that the judge should proceed in a manner to consider whether a non-custodial sentence is appropriate, but the same act excludes firearm offenses, and even if that statute had not been in existence, the general approach of the courts has been to impose a custodial sentence in cases of voluntary manslaughter. So we are getting closer, not yet there, but we are getting closer. So we now come to how sentencing is actually done. So since 2017, we have had sentencing guidelines. And I emphasize guidelines. It's not a statute. It's a guide. What is the purpose of the guide? The purpose of the guide is to establish a consistent methodology to the question of sentencing. It is not designed to produce mathematical equality. So what it's designed to do? So when you come to look at aggravating factors, there is no such thing as this aggravating factor equals 2 years, this other aggravating factor equals 6 years, this other one equals 0, this one is 10, and the mitigating factor, if this is present, it comes down by 6 months, it comes down by 10 years, and so on and so forth. It is designed to guide the thought process of the sentencer, who should articulate how he or she went about the sentencing process. So in the event, well, firstly, the defendant would need to know why he got the sentence that he did. Let's start there. Persons who may be connected in this case to the deceased would need to know how did the judge get here, even if they disagree with the judge and they go outside muttering afterwards that this judge is a real fool. But they would still be clear as to the process, as to how the judge got there. And also in the event of an appeal, the appellate court would have the advantage of seeing the thought processes of the judge to determine whether the methodology and the approach is in keeping with established principles. So we have the case of the Queen against Misha Clement, that has been the cornerstone of our sentencing practice. In that case, the late President of the Court of Appeal, the Honorable Mr. Justice Dennis Morrison, referred to the Trinidad and Tobago case of Aguilera and the state. And for those who are really interested in this, it's found at 89 West Indian Reports at page 451. And in that case, or rather Justice Morrison referred to that case with respect and admiration. And he suggested that that case had adopted a more nuanced approach to the fixing of the starting point, because this is the anchor point in sentencing cases. What is the starting point? How do you get there? What principles go into establishing the starting point? So Trinidad was having the same issues that we were, some would say still are, having. And the Trinidad Court of Appeal looked at New Zealand and looked at other jurisdictions as well to deal with this question of a starting point. And after the examination was done, the Trinidad Court of Appeal decided that the starting point is defined in this way. That is the sentence considered appropriate for the particular offense of an adult offender after a contested trial. And that is the definition that I'll be using in this case to establish a starting point. Remember, it's just a start. The other thing is this, that this way of approaching sentencing, this method, this new methodology, is different from what was called politely the synthesized approach or the instinctive approach to sentencing, where the judge just simply heard from counsel and then said, well, I think it is worth 15 years, and that was the end of that. Nobody knew what the considerations were. That is now considered to be inappropriate in modern sentencing practice. But one of the sticking points has been the starting point. How is it defined? How do you establish it? And so the Trinidad and Tobago has contributed, at least to my understanding, by saying it is the sentence considered appropriate for the particular offense, an adult offender, after a contested trial. So immediately, since it's a starting point, it is rare that it is going to remain there. The approach of the Court of Appeal of Trinidad and Tobago, similar but not identical to that of England and Wales, and also the Cayman Islands, where they seek to establish as well a starting point. And what I'm going to do is to indicate that using the Trinidadian definition of a starting point, going to indicate now what goes into the considerations to establish the starting point. And then here I'm going to be using the terminology from the Court of Appeal of the Cayman Islands, where they use the language of harm and culpability. What do they mean by harm? It refers to the result. What happened? How bad is the result? What actually happened? It asks as well what could have happened. And culpability looks at the blameworthiness of the offender. So it looks, was it deliberate? Was it spontaneous? Was it premeditated? Those are the things that go into establishing the starting point. Now, there's something that is also a bit more controversial, and it has to do with how firearms are looked at. And here I must recognize the contribution of my judicial counsel, Mr. Blackwin, or Shane Blackwin, who has been very helpful in doing the research in this matter. And in looking at the cases here from our Court of Appeal, there don't seem to be very many cases that seem to treat with firearm homicides as a unique or separate and distinct class. Other jurisdictions have done so. So once there's a use of a firearm, they say you start high. Why? Because it results in a death. And then now, so that's on the quote-unquote objective side of it. And then on the subjective side now, you look at was it premeditated, was it spontaneous, and so on, to get a sense of where you should start. The other thing too is that the harm culpability approach refined in the Cayman Islands establishes categories. So within, for example, the offense of murder, you might have 3 or 4 categories, and each category has its own band. So for the offense of murder, you may find 4 bands. Band 1, this is the range of sentencing. Band 2, this is the range of sentencing. Band 3, this is the range of sentencing. They have also done the same for manslaughter, and they have broken it down now into manslaughter by provocation, manslaughter by diminished responsibility, manslaughter arising from an unlawful and dangerous act. And within each of those categories, you have bands within them. So again, it's not a one-size-fits-all, because the idea is, while you recognize the seriousness of the offense, you also have to take into account the offender before the court to arrive at what is considered to be the appropriate sentence. So that is the approach that I'll be taking. And then when the starting point is established, then you look more closely at the aggravating, mitigating factors in this particular case. Then the next stage is to take account of things such as guilty pleas, previous behavior, good character, all of those things, and then you arrive at a final figure. So that's really the methodology. So from the research done, in Trinidad, as here, the maximum penalty for manslaughter is life imprisonment. One of the principles of sentencing is that maximum penalties are reserved for the worst of the worst, however defined. Some person may be wondering, well, how do you ever get there? Well, it's on a case-by-case basis. Some people are annoyed with that definition or approach, but there it is. So it is reserved for the worst of the worst. And the Court of Appeal of Trinidad and Tobago reminded us that even if the judge thinks that the penalties are low, the judge can't take it upon himself to say, well, in light of these low penalties, I am going to use the maximum as a starting point, because that is not the way it is to be done. So it is going to be very, very rare that the starting point is the maximum penalty in a manslaughter case. Notwithstanding that, the Court of Appeal in Trinidad and Tobago, they seem to operate in the range of 15 to 25 years for serious manslaughter. With regard to firearms, they give that special emphasis because in their view, firearms are inherently lethal and create significant risk to the public. And accordingly, offenses involving firearms in the Republic of Trinidad and Tobago are routinely placed towards the upper end of the manslaughter spectrum. And one case, Puran and the state, the court went as far as saying that where a firearm is deliberately discharged, substantial custodial sentences are justified, notwithstanding the presence of mitigating factors such as provocation or good character. In the Bahamas, that Court of Appeal there, they have identified a range of 18 to 35 years for serious cases of manslaughter. And they are of the view that manslaughter cases involving the use of a firearm should be to the upper end of the manslaughter spectrum. So too in Belize and also the Eastern Caribbean Supreme Court. So the sentencing methodology is not identical across those jurisdictions, but what seems to unite them is that firearm offenses are treated seriously and it elevates the starting point. Now, so I'm saying all of this to say that I'm not of the view that we're in Jamaica where we say that the range is from 3 to 15 is applicable here, since we did not and have not yet treated with firearm offenses in the way that other jurisdictions have. So since we are dealing with voluntary manslaughter, it is the case that then it's a voluntary and deliberate act. And Mr. Silvera is not claiming that the gun went off. He's acknowledging that he shot her, but he's saying there was a presence of provocative words and actions. I also take account of the fact that certainly okay. We're going to pause a moment here and I'm going to say this, so listen carefully now. No one is to have a cell phone or electronic device in their hands other than myself and counsel involved in the case. And the journalists. No picture taking is to be done. So if you don't have it in your hands, the temptation is reduced considerably. Or better yet, switch them off. So no picture taking. Okay? Yes. So, as I was saying that our approach, as in Jamaica, has not yet gotten to the point of Aguilera, what they've done in the Cayman Islands and so on. But nonetheless, let us make a start. This case is also taking place in a particular context. What is the context? That Parliament has indicated through the Firearms Prohibition, Restriction and Regulation Act, that the use of firearms to commit crime, whether licensed or unlicensed, is a very serious matter, and they repealed the old legislation and gave enhanced penalties. Now, we have a range, as I said, from 3 to 15. So it would be quite a remarkable thing to me if persons who commit non-fatal offenses with a firearm could end up with a higher sentence than a person who has committed a fatal offense with a firearm. So something just seems wrong about that. And so it is my view that in the present climate, reflected by legislative changes in other areas, homicide with a firearm could not be within the 3 to 15 range. It has to be higher than that. The other incongruity, it would appear to me, is this. The offense in count 1 charges the offense of using a firearm to commit a felony. Now, murder and manslaughter are not the only felonies that exist. Robberies are felonies. So again, you'd have the incongruous situation where a man who commits a firearm offense, in this case robbery, he may end up a longer time in prison because of the mandatory minimum, a longer time in prison than a person who has taken a life. So, that being the case, and having regard to what has been happening in other jurisdictions, how they've approached it, when you look at the harm, a death. A violation of the person's right to life, regardless of how provocative they may have been. The fact is, they have the right to life. And even persons on death row have the right to life. That is why the sentence is pronounced as to suffer death in the manner prescribed by law. So you can't have somebody running off the street and going on to death row and say, well, look here, man. Since you have been sentenced to death already, I'm going to save the hangman some trouble, and I'm going to kill you myself. So that wouldn't be death in the manner prescribed by law. So it was a deliberate killing, because that's what voluntary manslaughter is. And so in my view, a starting point should really be, in this case, about 25 years. So that is where I anchor the starting point. That is in respect of count 2. The harm was significant, and the culpability, in this case, the offender, is the principal in the first degree. It was his act that caused the death, and it was a deliberate and voluntary act. And that is also in the context of the movement to raise the levels of sentencing applicable to murder. So in my view, there should be a clear distinction between manslaughter and murder and wounding with intent. Yes, a very serious wounding with intent will maybe overlap with lower culpability manslaughter. A manslaughter sentence at the higher end may overlap a little bit with the lower end for murder, but nonetheless, the distinction between the offenses should be maintained, and offenses that involve a homicide should always be regarded as a class apart from any other sentence, if for no other reason that the victim's, the deceased's right to life has been violated in a fundamental way, and it is an irreversible state of affairs. Then now, having established this anchor point, the starting point that reflects the gravity of the offense itself, reflecting its seriousness, the degree of harm, the level of culpability of the offender, then we go on to the next stage now of whether there should be upward or downward adjustment. And just to make the point that when you're dealing with upward adjustment as a result of aggravating factors, downward adjustment, mitigating factors. Now, it doesn't mean that in every case there's going to be an aggravating factor or mitigating. So the judge is not to manufacture aggravating and mitigating factors. If none exist outside the commission of the offense, then that is it. So the judge can't go squeezing and torturing the evidence to find an aggravating or mitigating factor. Now, in this case, we have had submissions from counsel on both sides, and I thank them for their assistance. I mean, I really thank them, not saying it because it's something to be said. So we've also had the character witnesses as well, coming in from the defense. The Crown is emphasizing these factors that it says are aggravating factors. That is, Mr. Silvera would have known what happened. The Crown is also suggesting that Mr. Silvera has been before the court since 2024, early 2024, January 2024. So what he's saying is not really anything new, because he would have known about the argument in the bedroom. He would have known that he was the one who actually shot her. He would have known that she was either dead or dying when he left, and there is no evidence that he sought any assistance from anyone. You know, there's an accident at my home, please come. It was the discovery of the body by the children and the call based upon the narrative that brought him back to the house. So the Crown's position seems to be that he should not receive any discount because of the guilty plea, or very little because of the timing. And then, so we'll see what we make of that at the appropriate time. But that's the argument as I understand it. There's also a statute that regulates or has some assistance, provides some assistance here. This is the Criminal Justice Administration Amendment Act of 2015. And Part 1A speaks of reduction of sentence on guilty pleas. And in particular, it speaks to first relevant date, which means the first date at which a defendant who is represented by an attorney at law or who elects not to be represented by an attorney at law is brought before the court after the judge or magistrate, and this is the critical part now, is satisfied that the prosecution has made adequate, not complete, adequate disclosure to the defendant of the case against him in respect of the charge for which he is before the court. So the whole idea there of the legislation is that it is not the first day that you appear before the court, but what information did you have from the prosecution that would enable you to make an informed decision. And so the prosecution's argument is that disclosure was made in early January. Post-mortem examination was served as well. So they are saying, separate and apart from what he knew, he also had information that outlined that it was his firearm that caused death of this person. And so the prosecution is suggesting then that the delay in entering a plea was, my words now, not theirs, playing the odds. Let us go along, see what happens, and then I will make a decision. So the prosecution is suggesting that this was a tactical move on the part of the defendant. And so the prosecution is suggesting then that this guilty plea, helpful as it is, should not, Mr. Silvera should not benefit from the generosity of the statute to the fullest extent. Well, we'll see what to make of that at the appropriate time, but the cases do indicate that a guilty plea is of value. What is the value? One, it minimizes, well, it removes the trauma of witnesses having to testify. It frees up resources so that it can be dedicated to other cases, and the person has accepted responsibility. So if for no other reason, then it should be recognized as a mitigating factor. So we have to weigh all of that. So in my view, in looking at this matter, what are the aggravating features? This is a killing in the context of a domestic setting. Mrs. Silvera was in her house. It is a place that she was entitled to feel that she could be safe, or at least not shot and killed. And the children have been deprived of a mother. So those are aggravating features. Another, to me, aggravating feature, because the narrative of the Crown didn't indicate whether death was instantaneous or she was alive for some time. It wasn't clear on the narrative, but it means that if she didn't die immediately, then she would have been left there to succumb to her injuries. If she died immediately, based upon the narrative, these two youngsters, very young gentlemen, would have, as children normally do, you get up and you go into your parents' room. That's what children normally do, to stumble upon this there and leaving the children to make that discovery with no support. No, there's no evidence that any other adult was at the property. And so they did what children do, you call the other parent. And then when he came, pretending that he was just as surprised as anyone else about the death of Mrs. Silvera. All of these, to me, are aggravating circumstances. In addition to that, let me get back to the narrative here outlined by the Crown in respect of the ballistic evidence. Because it was the ballistic evidence that anchored Mr. Silvera to the crime. Because there's no report that the firearm was missing. No report that it was mislaid. No report that it was stolen. And his initial response to the police granted, I will accept that the police officer had a responsibility. You can't be there being taken in by all of this. You go and you see a body. As a police officer, you're not a pathologist, but at the very least, you should be saying, don't touch the body. Call the crime scene persons. Let us see what happened here. So I wouldn't expect the police officer to be going over there pretending as if he's a forensic pathologist. But the police officer, being, I suppose, misguided sympathy here, was being taken in by the act of Mr. Silvera, to the extent that the police officer now, rather than doing his duty, he is now treating this as if it's just an unexpected death that may have been by a heart attack or some such thing. And during that, Mr. Silvera would have known that he was the person who was responsible for her death. The post-mortem says she got 3 gunshot injuries. And he was even telling the police officer that as far as he knew, she had no known medical condition that would cause her to be in the state that she was found, which is all the more reason why the police officer should have been far more alert than he was. And I had conduct of the matter when it first came for trial in February. And I will never say that a defendant cannot exercise his right to have the prosecution case tested. I have no difficulty with that. I have no difficulty with seeking your own forensic services. I have no difficulty with that either. But the fact of the matter is that when the matter came up, the defendant wanted his own forensic person, and that's fine. But it's in a context where you knew what happened. You knew. And when the forensic legal professional privilege, I won't get into that, but the fact of the matter is that it seems to me that the effort here was directed to see if there was some room to maneuver regarding the ballistic evidence, because that was the anchor of the prosecution case. And then after you had that opportunity, then the guilty plea came. So in other words, from December 2023, right up to February 2026, it was a state of denial, non-acceptance of responsibility. So that is going to inform how I view the plea of guilty. Context matters. So yes, you have accepted responsibility, but it seems to me that the acceptance came because of the quality of the work done by the Jamaican ballistic experts. And what is the expert saying? The expert is saying two things. One level of marking, you get the firearm category. Two, next level of marking, I keep using the word marking. Matching, you get the specific firearm. And he's suggesting that what he saw in the barrel was not the result of the natural processes of corrosion and so on, but a deliberate effort. And he's also suggesting that the impact would be that bullets fired after the interference may be different in its markings and so on to facilitate identification, different from markings before the gun was fired. In other words, we can't be sure. So that's how I come to it. And September 29, 2023 is a significant date. It shows the value of proper processes. The value of proper processes is that the FLA did what it was supposed to do. You come to renew the license, give me your gun, let me look at it. Do I see any signs of tampering, corrosion, anything altering? Because what a part of their responsibility is to keep signatures of all firearms of private citizens so that the very thing that has happened here, the police investigation can proceed and you identify the firearm. But the problem was, and here's the problem. The problem was the pathologist. She was the fly in the ointment because when the body was removed, death from some cause other than violence. And it was the pathologist came along and said, what? No. We're going to deal with this differently now. It was her alertness. And based upon all the evidence, but for her alertness and professionalism, we wouldn't be here now. So that is part of the context for me. So those are the aggravating factors. Why are those lot of things aggravating to me? Because it suggested an effort now to disguise, to cover up, to escape. And the science put naught to that. And when you had your opportunity to have your expert examine, no wriggle room. The expert, the Jamaican expert, couldn't be discredited. So we are here. Now, on the positive side now, mitigating factors, which must be taken into account. No previous conviction, clearly. Person of good characters, King's Counsel said, you were an elected representative. Some persons may believe that is not necessarily a mark of distinction, but nonetheless, the electors of St. Mary found that you are a worthy person to represent, and that must be taken into account. There's no doubt about that. The evidence of your character witnesses, because as I've always said, if you have lived a hitherto a previously good life, and when you get into difficulty, your good character cannot assist you, then what is the point? So yes, it has to be taken into account. The impact on the children, that is to say, the surviving parent will be away from the children for some time. That's a mitigating factor. The social inquiry report speaks positively about your work, your contribution, the relationship with your children, and by all accounts, you're an effective father. And by effective, I don't mean just like functioning like an ATM now, but presence, active involvement, all of those have to be taken into account. The victim impact statements, Council made reference to them, I looked at them. The jurisprudence suggests that they are not to be used as an aggravating factor, but to be taken into account in determining the initial categorization of the offense, but it is not it's not supposed to have a decisive or impact to say the sentence goes up by a significant number of years, but it is factored into the process because there's always going to be a negative impact on those who are left behind. And it is not to be used to determine the level of sentencing ultimately. So it's taken into account. And as I said, and this is the difficulty in sentencing, there's no science that says aggravating factors mean you go up by 6 years, 7 years, or this particular factor is tied to a particular mathematical relationship. There's nothing like that. But nonetheless, it's a principle that we have to apply. And in my view, since I said the anchor point was 25 years, when you take into account the uplift as a result of the aggravating factors, I would say overall it goes up by roughly 6 years. The mitigating factors, it will come down by say, that will make it what, 31? From 25, the mitigating factors, you come down by say 4 years, that would leave it at 27. Now, having done that, we go to the statute now, where you look at things like the guilty plea. I note the words of the prosecution, and I am not seeking to undermine the defendant's right to have counsel. And of course, clients are like patients of doctors, they can give the advice, but they may or may not follow it. And so counsel has to work with the client that he has. I am not saying anything one way or the other, but it's just the nature of the job. A lawyer can only advise, but the clients have to decide. And sometimes it takes a bit longer for some persons to get to that point than others, and counsel may very well point out all the rational arguments as to why they should do things at a particular time, but some clients just don't act in the way that they ought to. There's nothing the lawyer can do about that, but you still have to work with the material that you have. So counsel referred to the Criminal Justice Administration Act of 2015, where it says, pursuant to subsection 1, the court may reduce the sentence that it would otherwise have imposed on the defendant in the following manner, where the defendant indicates to the court on the first relevant day that he wishes to plead guilty to the offense, the sentence may be reduced by up to 50%. Well, I don't think we're at the first relevant date. Let's go to paragraph B, where the defendant indicates to the court after the first relevant date, but before the trial commences, that he wishes to plead guilty, the sentence may be reduced by up to 35%. I think could say that he fits in there somewhere, where the defendant pleads guilty to the offense after the commencement of the trial, clearly not there. So where we are is paragraph B, after the first relevant date and before the trial commences. It says may be reduced by up to 35%. Now, what this provision is designed to do is to incentivize guilty pleas. But I suspect, and this is something now for law reform and the legislation, when you have the pairing of the offenses here of manslaughter, which the judge has more this discretion there, with using a firearm, which is a mandatory minimum, then you wonder how does a defendant get the benefit of this? Because if you plead guilty at the earth date, it's a minimum of 20 years, and if you plead 12 months later, it's still a minimum of 20 years. So that has to be taken into account as well, because there's really no benefit, really, for entering an early plea where you have a mandatory minimum of 20 years. So maybe the legislation should say something like, if he indicates on the first relevant date that he wishes to plead guilty, then notwithstanding the existence of a mandatory minimum, then the court can go below the minimum, because what you want to do is to incentivize persons to enter pleas rather than make it virtually pointless to enter a plea, since you're going to end up at more or less the same place, whether you go through a trial or you enter a plea. So I can understand those considerations. But nonetheless, he entered a plea, and it is of value. And I've indicated what that value is. So that should result in a further reduction. I don't think it's going to be as high as 35%, because of the context in which the guilty plea occurred, but nonetheless, it is a value. So, and in this particular case, had it gone to trial, quite likely the crowd would have had to call the children to give the evidence, and so that spared them the difficulty there, which is something that inures to his benefit. So again, there is no precise mathematics here, but in the context of this case, I think that is worth a further reduction of 4 years. That takes us down to 23. Not going to get into the percentage, but we're certainly not 35%. So that takes us now down to 23. This is in respect of count 2. other factor is a question of remorse. It's one of those intangibles where is the guilty plea a reflection of remorse or is it a tactical consideration? Well, I have indicated my position on that, and it seems to have been a tactical consideration rather than remorse. Though I acknowledge that he said in the social inquiry report that he's remorseful and all of those things, but having regard to the broader context, I think it was more strategic than remorse. But nonetheless, it's a guilty plea. Nonetheless, he has been in custody for 2 years plus, so that's 2 years from 23 and 16 days. Okay, let's call it 20 is what, 25, 26 months. 20, let's call it 26 months, 2 years down from 23, that makes it what, 21, and then you take out the 2 months, so that's 20 and 10 months. And I'm just checking to see if there's anything else that I need to bear in mind in terms of mitigating factors and their impact. And that seems to be it. I think that is it. Right. So, in terms of count 2, we are at 20 years, 10 months, and that's the time for count 2. In respect of count 1, well, I'm just a trial judge. I am not at liberty to ignore the words of the parliamentarians, and they have indicated that there is a minimum and a maximum, and they have indicated that the minimum is 20 years, maximum is 25. So again, a guilty plea is of inherent value, whether it shows remorse or not. At least that's my view. And so I can't go below what Parliament has said. I know Mr. Champagne has referred me to the decision from the Privy Council, but they are the Privy Council. So I think that it would be improper of me to do that, not because council is inherently wrong, but I think it is something that deserves full argument, that all the circumstances surrounding the legislation and so on, and all the relevant case law has been examined. It's very difficult to do that in the context of sentencing, and unless it's a clear authority from our Court of Appeal or the Privy Council to that effect. So on respect of count 1, sir, sentence is 20 years at a minimum. So the other principle of sentencing is that sentences arising out of, offenses arising out of the same factual circumstances are to run concurrently unless there is some good reason not to do so. There is no good reason not to do so in this case. So both offenses, sentences on both offenses, count 1 and count 2, are to run concurrently. So it's 20 years on count 1, 20 years, 10 months on count 2. And so we are now happily at the end of this process. So let me again thank Counsel for the Crown and Counsel for the Defense for the work that they have done. And again, to recognize the significant work done by my judicial counsel, who at times I gave him things to do at very short notice. I know that he was up late at night doing the research, so I thank him again. So he has enabled me to be here this morning to do this. And just again, a gentle reminder to the media, please do your reports in a manner that the persons, witnesses, or otherwise can be identified. Okay, so that's it then. So let's adjourn.
So there we have it, my viewers and my subscribers. Like you are seeing on the screen, you got 20 years. 20 years and 5 months on one, and 10 months on one count. 20 years on the other count. So you got 20 years. And the sentences are to run concurrently. So for the paper, him got 40 years and 10 months, but to run concurrently, meaning he'll be serving the 20 years at the same time. I am sure he'll be eligible for parole. So, boy, he got 20 years. He got 20 years. He got 20 years. We can argue, say, instead of get more, we can say whatever else, but no, Chantel, yeah, he got 40 years and 12, but the sentences are to run concurrently. So he'll be doing, in effect, he got 20 years imprisonment. 20 years. All right? So I think we have been here long enough. I still want to drop one news because there's a lot of stories I have to drop. A guy was killed over in Montego, St. James last night. A Chinese businessman took his own life last night in Westmoreland. We'll be bringing that to you also. Police killed two guys in Manchester last night. Look out for the news. I'm going to try and put it together. And no matter how late you drop it tonight, we're coming out. And we'll be back tomorrow morning again. And then tomorrow night with the Saturday night after dark show. All right? Some of us will never agree with the sentence, but the sentence was passed. We either accept it or we don't, but there's nothing we can do about it. You see, persons were arguing, persons were saying, boy, the judge talked too long. But you see, this is the first time, this is the first time we have been seeing anything in the court in Jamaica, or as far as I know, on we screen, apart from maybe the Court of Appeal, whatever. But this is what takes place in the court on a daily basis. And the judge has to come and outline his case because no care what sentence him pass, Jolyan can appeal. Jolyan can appeal the sentence, So the judge have to make sure he outline everything so that if him up, because the judge just come out and say 20 years without saying his reason, mitigation factor and aggravating factors, etc. It could be appealed and would be successful in the appeal. So the judge will make sure, he come out and say why he's arriving at this sentence. And he gave the reasons. Well, we must bear in mind, like the judge said, if the case had gone to trial, you know, there's nothing to say that a jury would find Jolyan guilty. So all we are saying should I get more and blah, 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 and them shouldn't accept the plea. We have to be mindful. Say there's nothing that would say, because I have seen some cases, you know, I've seen a guy charged for rape, you know, and the DNA come back and say, yes, he did it. And the lawyer, him decide, say, what in case try. And it go to court and him say, him know the female from Adams. And the jury let him go. The jury let him go. So not because the evidence might be overwhelming, no means say, I've seen judges run jury out of court and say, you'll never serve as jury again, you know. After them come back with not guilty plea based on the evidence, you know. So there's nothing to say. Anyhow, bless upon yourself. We're going over 4.5 hours. Thanks for joining. Catch us again tomorrow morning for another live. And tomorrow night for the After Dark show. We'll try to drop a video later, all right? Blessed love, everybody.
From the hills to the town, we bring the link. Straight facts, no mix up, no gimmick, no wing. You tune in now, get the real insight. Cause Papa News Link, lights in
Papa News Link, yeah, we tell it how it is. Jamaican vice, truth in the biz. Click it, share it, every little click out news with the vibes. And that we are now.